rules of the game for this afternoon. All speakers will be given the floor by a moderator. The moderators have to speak in English for ease of translation to avoid having to jump from one channel to the other. And all participants can make questions, preferably in the chat box, but you might also be able to raise your questions orally if time allows during the time we have for the debate. So with no further time, I give the floor to Mr. Ayat, who is the chair of the Committee on Enforced Disappearances. Mr. Ayat, you have the floor.
Il y a bien sûr une traduction en anglais ou dans les autres langues, n'est-ce pas?
Yes, 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 there is interpretation.
Français alors. Très bien. Merci beaucoup, Alban. Mesdames et messieurs, excellences, collègues et amis, c'est un honneur pour moi de m'adresser à vous en tant que président du comité sur les disparitions forcées pour ouvrir ce séminaire en ligne. Ce séminaire qui est organisé conjointement par le comité sur les disparitions forcées, le groupe de travail sur les disparitions forcées et involontaires et l'ICAED, avec le soutien toujours bien apprécié de la Geneva Academy. Nous sommes réunis aujourd'hui pour partager nos idées et nos expériences sur la promotion de la ratification universelle de la Convention pour la Convention internationale pour la prévention, pour la protection de toutes les personnes contre les disparitions forcées, ainsi que la reconnaissance de la compétence du comité pour examiner les plaintes individuelles et les communications interétatiques. Évidemment, je ne vais pas entrer dans la substance du sujet, car nous avons aujourd'hui la chance de compter sur la participation, sur la présence et la participation d'interlocuteurs de toutes les régions du monde. Chacun de ces interlocuteurs a une expérience riche et active, tant au niveau national qu'international. Une expérience qui porte sur les campagnes menées pour promouvoir la Convention. Je salue vivement la présence de tout le monde, la présence de tous ces interlocuteurs importants et leur engagement. Et avant de leur laisser la parole, je souhaite rappeler l'objectif de notre activité. Nous souhaitons d'abord apprendre et échanger sur les actions qui ont été menées pour encourager la ratification de la Convention depuis son entrée en vigueur. Nous souhaitons ensuite réfléchir ensemble sur comment nous pouvons continuer à faire, et ceci dès maintenant, dès demain, et dans les prochaines années, pour encourager tous les États à ratifier la Convention et à reconnaître toutes les compétences du comité. Les suggestions et les idées sur les futures actions à prendre et à entreprendre sont les bienvenues. Nous vous invitons également à bien profiter de cet espace pour échanger vos idées et vous mettre en contact les uns avec les autres pour coordonner nos actions futures. Le comité est pleinement engagé dans la promotion de la ratification de la Convention et nous comptons sur vous pour appuyer cet engagement afin de l'aider à obtenir les résultats positifs sans tarder. Les générations futures comptent sur nous tous pour que les disparitions forcées cessent dans le monde entier et que les droits inscrits dans la Convention deviennent réalité pour tous et pour toutes. Son Excellence Madame Michelle Bachelet, la haute commissaire des Nations Unies pour les droits de l'homme, nous fait aujourd'hui l'immense honneur d'ouvrir notre séminaire avec une allocution. Tout en la saluant, je l'invite cordialement à nous adresser son message.
I wish to express my sincere thanks for inviting me to address you. On 17 February 2017, my office launched a campaign before the General Assembly high-level plenary meeting on the occasion of the 10th anniversary of the adoption of the International Convention for the Protection of All Persons from Enforced Disappearance. At that time, a goal was set to double ratifications at the convention in the following 5 years. 4 years have passed since. In 2017, there were 55 state parties to the convention. Today, there are 63. The 8 states that have ratified the convention over this period have taken positive steps. However, I note with regret that we are still far from our objective of 110 state parties by 2022. My office has developed different initiatives to contribute towards reaching this objective, including campaigns and trainings in strong coordination with the Committee on Enforced Disappearance and the Working Group on Enforced or Involuntary Disappearances. Our regional and country offices have promoted the ratification of the Convention and the recognition of the mechanism established by the Convention. Their close follow-up and cooperation with the relevant national authorities and other stakeholders have contributed to specific developments, such as Mexico's declaration recognizing the committee's competence to receive and consider individual complaints, which occurred on the 1st of September 2020. In many instances, including Mexico's declaration just mentioned, victims and civil society organizations have played a key role to promote worldwide the ratification of the Convention and the full recognition of the competences of the Committee. Despite the challenges faced, they have carried out campaigns promoting the political and legislative processes that are necessary for the ratification of the Convention. In their decision-making processes, some states have been very receptive to arguments that truth, justice, and reparation are powerfully advanced, though ratification of the Convention, political will of and concrete action by states is of course indispensable in this context. In that regard, I would like to commend the actions taken by the group of friends of the Convention, co-chaired by Argentina and France. I also welcome that in the context of the Universal Periodic Review, the ratification of the Convention has been part of the recommendations that states consistently advance to their peers and that many states have accepted this recommendation. However, given the international community's common goal to eradicate enforced disappearances, promises and good intentions are not enough. It is urgent that all states ratify the Convention as well as consider the relevant declarations to enable the Committee to examine individual complaints and interstate communications. We know that the Convention stems in great part from the terrible practices of the dictatorships in Latin America in the 70s and 80s. It is, however, a mistake to consider it as a tool relevant only in relation to past crimes and to limited regions of the world. Indeed, enforced disappearance is a worldwide scourge. There are important reasons for its ratification by all states. To note just some, the Convention provides the most comprehensive and potentially global protection, enshrining as a human right that no one should be subject to enforced disappearance. The Convention also provides a shared definition of enforced disappearance, going beyond other binding universal human rights instruments. This definition has influenced the jurisprudence of courts as well as relevant human rights bodies. The Convention sets out a range of steps that states should take to prevent and eradicate enforced disappearance, as well as to address the terrible impact of enforced disappearance on individuals. For instance, it prohibits secret detention and calls on states to guarantee minimum legal standards around the deprivation of liberty, such as the maintenance of official registers of persons deprived of liberty and authorization to communicate with their family, counsel, or any other person of their choice. One of the Convention's major innovations was Article 24, which includes in the definition of victim not only the disappeared person, but also any individual who has suffered harm as a direct result of an enforced disappearance. It establishes comprehensive forms of reparation. Finally, the Convention also requires states parties to take appropriate steps concerning the legal situation of the disappeared persons, particularly with regard to social welfare, financial matters, family law, and property rights. Unfortunately, enforced disappearances continue to occur throughout the globe, and they continue to take new forms. The annual reports of the committee and of the working group and the cases that my office receives throughout the year provide clear data in that regard, and they demonstrate that every state can, at some point, be faced with the enforced disappearance of one of its nationals, be it within or outside its borders. When a disappearance occurs, the Convention and the Committee are there to support victims, states, authorities, national human rights institutions, and civil society organizations to ensure that their actions to search for and locate the disappeared persons and to give access to the truth, justice, and reparation. The Convention and the Committee are also there to ensure that if various states are involved, they cooperate to resolve the cases and support victims. The universal ratification of the Convention is a priority for my office, and I reiterate here our engagement to support this purpose through our different mandates. I welcome the initiative of the Committee on Enforced Disappearances and the Working Group on Enforced Disappearances or Involuntary Disappearances, together with civil society partners, to join forces to promote the universal ratification of the Convention. I take this opportunity to call upon all states parties to the Convention to engage with a group of friends of the Convention and actively contribute to their actions towards achieving universal ratification. And I invite all other states to ratify the Convention urgently, thereby demonstrating their clear commitment to eradication of all practices and forced disappearance. So let's act now.
Merci infiniment, Madame la haute commissaire pour Nations Unies pour les droits de l'homme, pour cette contribution, pour cette allocution très édifiante, je crois, qui donne déjà le ton de cette rencontre. Mesdames et messieurs, comme vient de le dire la haute commissaire, nous devons agir tous et maintenant. C'est donc sans plus tarder que je cède la parole à mon cher ami et collègue Olivier de Frouville, membre du comité des disparitions forcées, vice-président aussi de ce comité, qui va modérer la première partie de notre séminaire. En raison du nombre limité d'interprètes pour cette activité, nous avons dû demander à tous les modérateurs de réaliser leurs interventions en anglais, donc de donner leur contribution en anglais. Les traductions restent toutefois disponibles en français et en espagnol. Les interventions de nos invités seront réalisées dans la langue de leur choix. Nous regrettons les inconvénients causés par cette situation et tenons à remercier tout particulièrement les interprètes qui se sont portés volontaires pour permettre que cette activité ait lieu. Cher Olivier, vous avez donc la parole en anglais et merci.
Merci beaucoup, Monsieur le Président. Merci, cher Mohamed. So I will switch to English, and I would like to thank very much the International Coalition Against Enforced Disappearances, the ECIAD, for having taken this initiative. Of course, the committee and the working group gladly accepted to join in organizing this event, which we think comes at a crucial moment, a bit more than 10 years after the entry into force of the convention. And I would like in particular also to thank the Secretariat of the committee for all the efforts, and also the Geneva Academy for hosting us in its webinar. After the adoption of the convention in 2006, the victims' associations formed the coalition, the International Coalition Against Enforced Disappearances, and launched an international campaign for the universal ratification of the convention. Much have been done since then, but we also all acknowledge that much remains to be done. And we can hope that this seminar will give a new impetus to the campaign of ratification. The organizers of this webinar have considered, rightly, I think, that to achieve progress, we have to look at the good practices, and in particular at what the states that have ratified the convention have done to reach that goal. This is the purpose of this first panel that I have the honor to moderate. And we will hear from high-level personalities from a range of countries about their experiences. Why they decided to ratify the convention, what did it imply at the domestic level in terms of political process, but also in terms of legal change. Before passing the floor to the first speaker, I would like to remind everybody that the speakers have a maximum of 7 minutes each, so that there will be some time, so that we can make sure that there will be some time left also for the questions and the answers. All the participants have the possibility to raise questions orally after panel 2, that will be moderated by my friend Bernard Duhem. And there will be a dedicated slot for questions and answers after panel 2. For the sake of time, we would encourage everybody to raise the questions in writing in the chat box. Thank you very much. So first, I would like to pass the floor to Mr. Horacio Cesar Pietragala Corti, who is the Secretary of Human Rights of the Argentine government. Previously, he has also been a member of the Argentine Parliament, and he was also appointed as the President of the National Archive of Memory. It is particularly relevant in the context of this webinar to mention that Mr. Pietragala's parents were forcibly disappeared during the Argentine dictatorship, and that he was also himself a victim of appropriation and falsification of identity. In 2003, he was returned to his biological family with the support of the grandmothers of Plaza de Mayo. Mr. Pietragrala has been a member of the Grandmothers de Plaza de Mayo Association since he recovered his identity in 2003. Mr. Pietragrala, thanks for being with us today to share the experience of Argentina in the ratification and promotion of the convention. You have the floor, sir.
Bueno, buenos días a todos. La verdad que voy a hablar despacio en español. Para nosotros es de suma importancia poder estar en este congreso, en este encuentro, para rectificar, para reafirmar el compromiso que tiene el Estado argentino con la Convención y por su propia historia y lo que generó Argentina a partir de su propia historia, las herramientas, digamos, para que esta convención se pueda ir llevando adelante. Primero pensándolo en esos grupos de trabajo que en plena dictadura en Argentina los organismos de derechos humanos denunciando de manera internacional, justamente por la prensa que había llegado en el año 78 a visitar el país y donde las madres y las abuelas de Plaza de Mayo pudieron tener ese primer contacto con los medios internacionales, esas denuncias llamaron la atención de la comunidad internacional, pero también de organismos internacionales, y a partir de ahí se abrió un camino. Un camino que siempre digo que Argentina tiene la fortuna de contar con esa marca que ya es una marca registrada de nuestro país, que tiene que ver con esos pañuelos blancos, que son nuestras madres de Plaza de Mayo y nuestras abuelas de Plaza de Mayo. Quiero decir que sin la lucha de estos organismos y, obvio, el acompañamiento de ex detenidos, de abogados que llevaron adelante un compromiso férreo en la defensa y en la denuncia, en la defensa de los derechos humanos y en la denuncia de la desaparición y de lo que se estaba viviendo en Argentina en esos tiempos, fueron los que abrieron un surco para que hoy estemos sentados acá también, ¿no? Paradójicamente, esos caminos que tuvieron muchos avances y retrocesos a través de los años democráticos en nuestro país, pudieron ir forjando un grupo de trabajo para ir pariendo, digamos, lo que fue la Convención contra la Desaparición Forzada. El primer coloquio en París en 1981, donde, bueno, se contó con la participación de juristas y prestigiosos académicos, pero también con organismos de derechos humanos que viajaron para ese coloquio, y a partir de ahí se forjó un camino que no tuvo pausa, ¿no? La verdad que en esto quiero destacar el rol de los familiares, de los organismos de derechos humanos, de toda Latinoamérica, de FEDEFAN, de Marta Vázquez, que llevó adelante una lucha, una querida madre de Plaza de Mayo, que llevó adelante una lucha inclaudicable para que gobiernos puedan ir firmando esta convención, adhiriendo a esta convención, y cada vez seamos más los que tengamos un compromiso contra este delito aberrante. Nosotros desde Argentina saben muy bien que ya va a ser la tercera campaña que empezamos en breve con nuestra República Hermana de Francia. Son 3 las campañas que ya se llevaron adelante, 2 que se llevaron adelante, ahora va a empezar esta tercera campaña, donde, bueno, tanto Argentina con sus aliados estratégicos y Francia con sus aliados estratégicos también, llevaron adelante un trabajo muy fuerte en las naciones para el compromiso de la firma de esta convención, de la adherir a esta convención desde los estados. La verdad que para nosotros no solo es importante la firma, que los estados se comprometan en esta convención, sino también poder llevar adelante una política pública dentro de nuestro Estado que rectifique realmente, ¿no?, esta firma y este compromiso internacional que tiene Argentina. La verdad que venimos, y no se puede disociar un poco, pero lamentablemente es cuando hay gobiernos que dejan a un lado los derechos humanos, corremos riesgos de tener retrocesos muy grandes, ¿no? Cada gobierno que abandona esta lucha y que abandona las políticas públicas contra estos delitos, la verdad que nos generan un retroceso de años. Y eso es lo que tenemos que generar en nuestra sociedad, pero también en la conducción política de los distintos espacios, no importa la ideología que tengan, pero también en las fuerzas de seguridad de nuestros estados, ¿no? Creo que por ahí es el camino que nosotros políticamente, para adentro, digamos, en nuestro ejecutivo estamos llevando adelante. La formación de las fuerzas de seguridad sobre esta problemática para nosotros tiene que ver con defender la democracia y las instituciones más allá de los colores partidarios de quienes nos gobiernan, ¿no? Creo que ahí es uno de los puntos donde hacemos más hincapié. Nosotros hablamos siempre de violencia institucional. Es uno de los delitos que puede acarrear, digamos, desapariciones forzadas. La violencia institucional, la violencia en manos de las fuerzas de seguridad, tanto fuerzas armadas como fuerzas locales policiales, ¿no? Creo que ahí tenemos un trabajo que necesita mucha rapidez para llevarse adelante, pero con mucho compromiso de los distintos arcos gobernantes de un distrito tan amplio como es Argentina y con sus fuerzas de seguridad federales, pero también con sus fuerzas de seguridad provinciales, que sabemos que cada provincia tiene una autonomía en esa fuerza. Nosotros estamos comprometidos, como dije, con la defensa férrea de los derechos humanos, no solo por cada historia personal, sino porque somos un proyecto político que tiene como pilar fundamental la bandera de los derechos humanos. Cristina Fernández de Kirchner tuvo un compromiso muy grande con la Convención Internacional en su mandato, en su presidencia, fue cuando Argentina impulsó las medidas más innovadoras a nivel internacional, pero también a nivel local, para promover la convención, pero también para llevar adelante políticas internas que defiendan los derechos humanos y que combatan la desaparición forzada de personas. Pasaron muchos años, como dije antes, de nuestra democracia. Tuvimos años de impunidad en nuestro país también, y esto quiero dejarlo muy en claro porque para nosotros sí es un aporte que podemos hacer desde Argentina. Somos uno de los pocos países de Latinoamérica que ha podido condenar, por suerte y por decisión política, a todas las instancias de responsabilidad de la dictadura. Es más, hoy estamos celebrando el inicio de un juicio de responsabilidad económica también de esa dictadura. Nosotros no solo condenamos a los responsables ejecutores del terrorismo de Estado, sino también a los responsables civiles, a la complicidad civil, a la complicidad económica de esa dictadura. ¿Qué quiero decir con esto? Que no me quiero extender mucho más. Para nosotros poder, con la sanción, con el juzgamiento de los genocidas, de una dictadura militar, que ya pasaron, vamos a cumplir 45 años de ese golpe militar, y hubo muchos años de impunidad, pero haber podido abrir ese proceso de juzgamiento, creo que es la marca más adherente que puede tener un Estado para erradicar realmente la problemática y generar una concientización masiva, emancipadora en nuestra sociedad. La no impunidad, el juzgamiento, el castigo de los responsables, creo que lleva adelante una marca indudable de que por dentro de la ley todo y por afuera de la ley nada. creo que un país que lleve adelante políticas de impunidad, lamentablemente, en su futuro puede volver a cometer errores del pasado, ¿no? Estamos en contacto con organismos de derechos humanos de toda nuestra patria grande, como decimos, de Latinoamérica, y tienen celos sanos del proceso de juzgamiento que lleva Argentina, porque creo que va de la mano. La impunidad va de la mano con que cada vez tengamos casos de desaparición forzada. Y quiero decir que Argentina, como dije antes, está iniciando una nueva campaña con Francia para concientizar y para seguir juntando cada vez más votos, pero también Argentina está llevando adelante una campaña internacional por el derecho a la identidad, porque si bien saben, nosotros en Argentina tuvimos un delito que para mí, y esto lo fuimos comprobando, que se cometieron en otros países, pero esos países no tuvieron la suerte de tener unas mujeres como las abuelas de Plaza de Mayo que denunciaron y nunca claudicaron en su denuncia. Y hoy Argentina está armando una campaña internacional para concientizar por las migraciones que tuvo Argentina en todos sus años de democracia post-dictadura, concientizar en distintos países por el derecho a la identidad. Salimos a buscar a nuestros hermanos que fuimos apropiados por la dictadura militar en otros países, porque ya hemos encontrado nietos que recuperaron su identidad, que pudieron saber su verdadera historia en otros países de Europa y de América y del continente americano. Así que nosotros vamos a alargar una campaña internacional, ayudarnos a encontrarte. Son víctimas de desaparición forzada con vida, esos más de 200 hombres y mujeres que todavía no conocen su verdadera historia, ¿no? Y creo que poder llevar adelante esta campaña también genera concientización en los distintos países que cometieron estas aberraciones. Sabemos que gracias a la lucha de abuelas de Plaza de Mayo, hay países que están hablando recién hoy de la apropiación y el robo de bebés que hubo tanto en guerras civiles como fue la Guerra Civil Española, como fue el franquismo en España, una feroz dictadura que vivió el país de España y que hubo apropiaciones de menores, pero también en dictaduras de América Latina. No me quiero extender en el tiempo, quiero decir que cuentan con Argentina, un aliado estratégico en la convención para seguir sumando países y voluntades que apoyen y firmen la convención y este tratado para combatir la desaparición forzada de personas en el mundo, ¿no? La verdad que creo que en esto, y más allá de algún chiste que nos puedan hacer por Messi o Maradona, la verdad que les puedo asegurar que uno de los orgullos más grandes que tenemos es de poder haber profundizado y emancipado las políticas y la defensa en derechos humanos en nuestra República Argentina. Como dije antes, estos 45 años, vamos a cumplir 45 años del golpe y del Estado argentino vamos a homenajear la lucha y la resistencia de los organismos de derechos humanos. Gracias a todos por la atención y gracias a todos por la invitación.
Thank you very much, sir, for this statement, this testimony, and also this statement. I think which is very important to us. It's also very important to know that you are here to help not only the committee and the working group, but the victims and also all the states that are willing and have the intention to progress towards the ratification of the convention. I would now like to pass the floor to Mr. Alejandro Encinas, who is the Undersecretary of Human Rights of the Government of Mexico. Before he was appointed to that position, he also held the position of Secretary of Environment, Secretary of Economic Development, Secretary of Government, and Head of Government of the Federal District. Mexico ratified the convention in 2008 and recognized the competence of the committee to examine individual complaints in June 2020. The process of ratification has involved many sectors of the Mexican society. and Mr. Alejandro Encinas. You now have the floor so that you can tell us about the experience of Mexico. Muchas gracias.
Al contrario, muchas gracias. Muy buenos días tengan todas y todos ustedes. Agradezco la invitación del Comité contra la Desaparición Forzada, del Grupo de Trabajo sobre Desapariciones Forzadas e Involuntarias y, por supuesto, a la Coalición Internacional contra las Desapariciones Forzadas a la realización de este foro. Como ya se ha señalado, nuestro país suscribió la Convención Internacional contra la Protección de todas las personas contra la desaparición forzada en febrero de 2007 y en marzo de 2008 firmó, depositó este instrumento como de la ratificación de la Convención. Sin embargo, y a pesar de que la Convención entró en vigor el 23 de diciembre de 2010, no suscribió ni aceptó la competencia del Comité para conocer de comunicaciones individuales. Esa es una situación que a lo largo de casi 10 años estuvimos debatiendo con el gobierno mexicano, antes en la oposición, en mi caso como senador de la República, y había una negativa en primer término a reconocer la magnitud de la profunda crisis humanitaria y de violación a los derechos humanos que vive nuestro país y que durante mucho tiempo pretendió minimizarse y desconocer. A la llegada del actual gobierno asumimos nuestro compromiso para la defensa plena de los derechos humanos y aceptar las responsabilidades del Estado para garantizar su ejercicio pleno. Así, pongo como ejemplo, el 3 de diciembre, 3 días después de asumir el gobierno de México esta nueva administración, asumimos en la Comisión Interamericana de Derechos Humanos la existencia de esta crisis humanitaria y de violación a los derechos humanos y asumimos el compromiso del gobierno de México para que en los casos específicos de desaparición forzada hiciéramos investigaciones de fondo para acabar con la impunidad y hacer justicia. El propio presidente de la República, Andrés Manuel López Obrador, asumió un compromiso con los familiares de las víctimas de desaparición para ratificar la competencia del Comité de Desapariciones Forzadas y después de un largo proceso de discusión para prepararnos y poder cumplir con nuestras responsabilidades, el 2 de octubre depositamos, después de la aprobación de la ratificación por parte del Senado de la República, ratificamos nuestro compromiso con el Comité de Desapariciones Forzadas. ¿Cuáles fueron las principales resistencias que alegó los gobiernos anteriores de nuestro país? En primer lugar, dentro de estas yo resaltaría 9 resistencias que enfrentamos en estos 10 años hasta el reconocimiento de la competencia. Primero se alegó que podría haber invasión a la soberanía de nuestro país al permitir que jurados internacionales intervinieran en asuntos que son competencia estricta de las autoridades mexicanas, lo cual es falso desde el momento en que el gobierno de México había suscrito originalmente la convención. Señalaron algunos argumentos absurdos, que se iban a recibir decenas o cientos de recomendaciones por parte del Comité de Desaparición Forzadas, que existiendo un registro en aquel entonces de 40,000 personas desaparecidas, se inundaría de denuncias contra el Estado mexicano por parte del comité a partir de la aceptación de su competencia, lo cual también ha sido evidenciado como falso. No solamente los datos que reconocía el gobierno de México a finales de 2018 era de 40,000 personas desaparecidas. Hoy asumimos nosotros con toda responsabilidad la existencia desde 1964 de 80,080 personas al día de hoy, lo que daba cuenta también de la simulación y el ocultamiento de la información sobre la magnitud de este problema que enfrentamos en el país. Se afirmaba que la aceptación implicaría un desfalco al erario público por las sumas indemnizatorias que ordenaría el Comité al Estado mexicano cuando el Comité no establece montos de indemnizaciones. Se señalaba que la aceptación causaría una carga de trabajo significativa a las autoridades mexicanas porque habría que ir adoptando todas las medidas. Señalaron que la aceptación del comité sobre funcionarios emitirían acusaciones concretas contra servidores públicos o contra instituciones, particularmente contra las Fuerzas Armadas o la entonces Policía Federal Preventiva, y señalaban que esto implicaba un riesgo para que la Corte Penal Internacional conociera de casos contra funcionarios públicos en nuestro país. Se estuvieron alegando muchos obstáculos y hemos decidido romper con esta inercia. El 2 de octubre del año pasado, una fecha emblemática para nuestro país, es el aniversario de la matanza de los jóvenes estudiantes en Tlatelolco durante el movimiento estudiantil de 1968, se depositó este instrumento que tiene hoy mayores instrumentos para poder garantizar pues el acceso a la justicia y enfrentar a quienes hayan cometido desaparición forzada en nuestro país. El caso de la reforma constitucional sobre derechos humanos, que elevó a rango constitucional en 2011 en el artículo 1 de nuestra Constitución los derechos humanos, la publicación en 2017 de la ley contra la desaparición forzada o la ley o la desaparición cometida por particulares, y los nuevos instrumentos que hemos venido creando en estos 2 primeros años de gobierno. Un sistema nacional de búsqueda que cuenta con una Comisión Nacional de Búsqueda de Personas, que al mismo tiempo ha integrado con 32 comisiones locales de búsqueda, el diseño de un mecanismo extraordinario de identificación forense enfrentando el enorme rezago y crisis forense que tiene el país, la publicación de un protocolo homologado de búsqueda, un registro nacional de personas desaparecidas y no localizadas, que ha sido resultado no solamente de la actitud de la nueva autoridad, sino principalmente del impulso, del apoyo, de la demanda, de la exigencia de las familias, de las personas desaparecidas, que han sido un factor determinante para construir el marco legislativo y las estructuras institucionales para enfrentar este reto. Tenemos también que enfrentar hoy el enorme rezago que tenemos en materia de castigo a los responsables, acabar con la impunidad en este delito. Y por eso consideramos que el abrirnos al escrutinio internacional, el permitir la intervención del Comité de Desaparición, el conocer de los casos particulares, va a ayudar a fortalecer nuestra política en materia de defensa de los derechos humanos, de dar su garantía y acabar con la impunidad en el país. Nosotros vamos a cumplir puntualmente con esta responsabilidad que hemos asumido y, por supuesto, estamos a la disposición de la atención del Comité de Desaparición Forzada, y les quiero reiterar el día de hoy la invitación para que visiten a la brevedad nuestro país. Sabemos de las limitaciones que hay por la pandemia que estamos atravesando, pero sería muy importante que este mismo año ya hubiera una visita oficial del comité para que pudiéramos realizar trabajos de manera conjunta. Aprecio mucho esta invitación y estamos aquí a sus órdenes para las preguntas que quieran formularse. Muchas gracias.
Thank you very much for your comments and your intervention, sir. I think this is very useful, a lot of information, and we also note the invitation by Mexico for a visit to the committee, and we'll certainly come back to you on this point. I would now like to introduce the next speaker, Ms. Elin Winstein. Since 2010, Ms. Winstein is the International Law Advisor at the Norwegian Ministry of Foreign Affairs. Before, she was the Deputy Permanent Representative of Norway's Permanent Delegation to the Council of Europe and the First Secretary of the Norwegian Embassy in Guatemala. She also holds various other positions, held other positions in the Norwegian Ministry of Foreign Affairs. Ms. Winstein actively participated in the ratification process of the convention by Norway, which is as of today, the latest European country that has ratified the convention. Norway signed the convention in 2007 and ratified it in 2019. Ms. Winstein, thank you very much, and you have the floor.
Thank you so much for the introduction. And I just have to say that some work just started in my building. I really hope that it will not disturb us too much during the intervention. I'm sorry for that. Buenas tardes, bonjour tout le monde. I was, as was already said, in charge of the process of the ratification of the Convention on Enforced Disappearances in Norway. And I will try to say a few words about my experience with this convention, seen from a country in which enforced disappearance is not a problem. As also have already been said, Norway signed the convention in 2007, but did not ratify it before 2019. And I have to admit that we still have not recognized the committee's competence pursuant to Article 31 and 32 of the convention. In Norway, no one ever questioned whether Norway should ratify the convention. The legal safeguards in the convention against enforced disappearance were considered to follow to a large extent from other human rights treaties Norway was a party to. Due to these legal safeguards, enforced disappearance was considered not to occur in Norway. By ratifying the convention, Norway wanted, however, to support the objective of the convention, which is to combat enforced disappearances globally. Ratification would, for instance, enable us to implement the provisions of the convention if a person in Norway has contributed to an enforced disappearance abroad. So why then did it take Norway 12 years from signing the convention to ratifying it? We encountered two main obstacles in the ratification process. There were other issues as well, but these were perhaps the ones who retarded us the most. Firstly, we in the Ministry of Foreign Affairs considered it necessary to act criminal provisions against enforced disappearances in the penal code before ratification. It was, however, very difficult to get a very busy Ministry of Justice to give priority to this work. Since enforced disappearance is not considered a problem in Norway and therefore not part of the public debate, other issues were always more pressing for the Ministry of Justice. So in the end, the Ministry of Foreign Affairs offered to help the Ministry of Justice with the preparatory work, which enabled us to go forward on this issue. It took us a long time due to this obstacle. Secondly, and perhaps more important, is that the right of relatives to information about deprivations of liberty in Article 18, combined with Article 20, first paragraph of the Convention, raised difficult interpretive questions in relation to Norwegian privacy legislation. Civil servants in Norway are bound by a duty of secrecy concerning anything that comes to their knowledge in connection with the work concerning an individual's personal affairs. This includes, in principle, the information that a person is or has been deprived of his liberty, whether it is in the criminal field or in the health and care sector. The duty of secrecy does not prevent the information from being disclosed to others, insofar as the person to whom the duty of secrecy is owed consent thereto. So if the person deprived of liberty consents to the information being closed, there is no problem related to Article 18. The problem in relation to Article 18 of the Convention arises if the person deprived of liberty does not consent to the disclosure of the information to his relatives. In such cases, the general rule in Norway is that information cannot be given to relatives. There are, however, I underline, many important exceptions from this general rule. In the health and care sector, for instance, the closest next of kin of the person deprived of liberty will normally be notified or get access to information concerning the deprivation of liberty, even if the person concerned does not wish so. So, what does the Convention say about this? It follows from the Convention, Article 20, first paragraph, that when a person is under the protection of the law and the deprivation of liberty is subject to judicial control, the right to information in Article 18 may be restricted on an exceptional basis where strictly necessary, and if the transmission, for instance, adversely affect the privacy of the person. This provision can be subject to different interpretations. In Norway's view, it is very important that the conditions in Article 20 of the Convention is interpreted in a way that does not unnecessarily infringe on the privacy of the person deprived of liberty in situations where all the legal safeguards against enforced disappearances are in place, and there therefore, in principle, is no reason to suspect an enforced disappearance has taken place, and where there are also independent mechanisms that can verify that the person has not been subjected to an enforced disappearance. Due to these privacy concerns, Norway saw it necessary to make an interpretive declaration concerning Article 20, first paragraph, in conjunction with Article 18 upon ratification of the Convention. Germany has also done that. So, the ratification process in Norway took a long time due to especially these two issues that I have mentioned, and the privacy issue concerned the legislation of 4 ministries, which complicated the matter. At the same time, there was not much pressure on the authorities to ratify the convention from the civil society, contrary to what was the case, for instance, with ICPR. We received a few letters from the National Human Rights Institution and other human rights organizations. Argentina and France also often raised the question of ratification in bilateral meetings, including with other politicians. I can confirm that such campaigns have a certain effect. To conclude, I think it's important to communicate to states where enforced disappearance is not a problem, why the ratification is important. I have touched a little bit upon it. You can, if it's not a problem in your country, you can help to combat it internationally if you have somebody on your territory who has contributed to an enforced disappearance. But at the same time, I also think it's important that the convention is interpreted by the committee in a way that does not create unnecessary impediments against ratification, such as legitimate privacy concerns in states where enforced disappearance is not a problem. Thank you. That was all I had prepared to say.
Thank you very much. That was a lot already, and it's a very interesting experience, as you said, to have also the testimony and a statement by a state that that did not have any problem with enforced disappearances in the past. So thank you very much. I'm sure we'll come back on this. I would now like to introduce the next speaker, with Mr. Abdel Salam Siddharmed. Mr. Siddharmed is the Senior Human Rights Advisor of the Prime Minister and the Minister of Justice of Sudan. Previously, he worked for over a decade for Amnesty International, first as a researcher, then as a program director for the Middle East. And he also worked for the Office of the High Commissioner for Human Rights as head of the country office in Yemen, and was the regional representative for the High Commissioner for the MENA region in Beirut, Lebanon. Before his last assignment as Senior Human Rights Advisor, he worked as the head of the UN Human Rights and Documentation Center in Doha, Qatar. Sudan recently announced that it is in the process of ratifying the convention. The experience of the country is therefore of particular relevance in the context of our webinar today, and we very much welcome your remarks, Mr. So you have the floor, please.
Thank you. Thank you very much. Good afternoon, everyone. I'm really honored to be with you today. to say a few words about the experience of Sudan or situation of Sudan. Yes, as Mr. Olivier, the chairperson, just mentioned, Sudan, as a matter of fact, only last week did approve ratification of the Convention of protection of all persons from enforced disappearance, together with the Convention against torture. This was last week on the 23rd of February. The decision actually was adopted by the Council of Ministers a few months back, but it has to be approved according to the constitutional arrangements in the absence of a legislative assembly. All laws and important policy decisions will have to be approved by a joint council sessions, Supreme Council and the Council of Ministers. So this has taken place last week, as I said, 23rd of February. And as you can see, it is quite fresh. So we haven't yet, completed the process of, sending the papers, ratification paper to New York to be formally, filed at the UN. Now, prior to this step, which we regard as quite an important step, and I'll tell you why it happened now. Prior to this, Sudan had ratified only 5 of the core international human rights treaties. These are the 2 covenants, civil and political rights, economic, social, and cultural rights, as well as Convention on the Right of the Child, racial discrimination, and people with disability. Sudan signed the Convention Against Torture in 1986, but did not ratify until last week. So basically, Sudan was rather behind, and that has something to do with the political, hegemony of, oppressive governments that dominated the history of the speaking, about the history of the Sudan political system. The recent changes happened as the result. I don't know. Everybody can hear me. I don't know if. Yeah.
Yes,
okay.
absolutely. We hear you very well.
Okay. Now, so the recent changes, maybe most of you are aware, or all of you are aware, that there was a revolution in Sudan that started in December 2019, culminated, 4 months of protests led to the, overthrowing of the previous dictatorship in April 2019. Sorry, it started in 2018 in December, and culminated in the overthrowing of the government, the previous head of state, Mr. Bashir, in April 2019. And then a constitutional document was adopted to oversee or set the framework for the transitional period in August 2019. Significant about the constitutional document is that it contained a Bill of Rights that outlined most of the rights, human rights we know, as part of as constitutional rights, and recognized that all the international human rights treaties to which Sudan is the party are part and parcel of the constitutional document. Hence, this ratification is quite significant, because once it is ratified, then the Enforced Disappearances Convention becomes part and parcel of the Sudan constitution or constitutional document. A lot of work lays ahead. Obviously, as I said, the formal ratification process will have to be completed, and at that point, or maybe a little bit later, we can see whether Sudan can make a declaration about the competence of the committee to explore, investigate, or consider individual complaints. There are still other, treaties like CEDAW that Sudan has yet to ratify, and work is going in that regard. And then obviously there is need for legal reform to bring domestic laws in conformity with the convention, among other things. And of course, institutional reforms also are needed in order to improve the capacity of the justice sector also to deal with this issue. And then I'll probably maybe mention a little bit on some of the triggering factors that also enhance the issue of ratification. I mean, the ratification had been in the works for some time, but the main thing, of course, had been the political change in the country as a result of the revolution. That is the major development. However, some of the developments that took place in the country over the last 3 decades definitely resulted in a number of human rights violations, including cases of enforced disappearances. And I will mention maybe 3 probably issues here. One is the conflict in Darfur in Western Sudan, as you probably, some of you have followed, and the conflict definitely resulted in a number of cases that are yet to be properly investigated of enforced disappearances in a number of villages and places in Darfur. Then during the previous regime also, there were particular incidents that resulted in cases of enforced disappearances, either because the authorities did not clearly explain the whereabouts of the people who were lost, or as a result of the people who were either judicially or extrajudicially executed by the state, and their families did not also know exactly whether these people have actually been killed or executed or not, or where are their remains. And then on the third incident or series of incidents that happened during the revolution itself, there are a number of cases of enforced disappearance that took place during the 4 months period of the protest. And then on the 3rd of June 2019, when in a popular sit-in before the army headquarters was violently disbanded, by still a group of armed groups or whatever that are yet to be investigated. There is a commission of inquiry about in that regard. So basically, these are some of the incidents that definitely are part and parcel of the disappearances cases in the country. It's not as maybe on the scale of other countries, but definitely any human rights violation is an issue, is an important. And the important thing is that the convention itself put some guarantees and mechanisms in place that would ensure protection of all persons from disappearances, and definitely enhance the capacity of the judicial bodies also to protect people from enforced disappearances. And I'll be happy to comment on or respond to any questions you may have, but maybe it's better to stop here to save more time. Thank you very much, Chairperson, and greetings everyone. Thank you.
Thank you very much, Mr. It was great to hear about the progresses which have been made by Sudan, and we are very glad to know that now Sudan has ratified the convention, and we're looking forward to receive the instruments of ratification. There has been a lot of message of congratulations in the chat, but allow me also to congratulate Sudan for this major step. So thank you very much. Lastly, I would like to pass the floor to the next speaker, with Ambassador Francoise Vassou, who is the permanent representative of France to the United Nations, and other international organizations in Switzerland for almost 3 years. In his career as a diplomat, he has held several positions, including spokesman for the Ministry of Foreign Affairs and permanent representative of France to the Conference on Disarmament. Within the Human Rights Council, Mr. Vassou has led the campaign for France's return to the Council, which occurred on 1st of January 2021. And he conveys France's voice on issues related to enforced disappearance, torture, the defense of human rights defenders, gender equality, and defense of multilateralism, but also of multilingualism. So, Monsieur l'Ambassadeur, vous avez la parole.
Merci, cher Olivier, messieurs les présidents du comité et du groupe de travail, chers collègues, señores Secretariat of Derechos Humanos y Undersecretary of Human Rights, dear colleagues. Je vous remercie d'avoir organisé cet événement qui, pour nous, doit marquer le point de départ d'une relance de la campagne pour la ratification universelle de la Convention. L'année qui vient de s'écouler a été pénible à divers égards, mais elle a marqué quand même 2 anniversaires importants. Les 40 ans de la création du groupe de travail des Nations Unies sur les disparitions forcées, nous l'avons célébré en mars dernier à Buenos Aires aux côtés de nos amis argentins, et les 10 années de l'entrée en vigueur de la Convention pour la protection de toutes les personnes contre les disparitions forcées et de la création de son organe de suivi, le Comité sur les disparitions forcées. Durant toutes ces années, l'engagement du groupe de travail et du comité ont permis de documenter de manière précise des cas de disparition forcée, ce qui a contribué à la lutte contre l'impunité des responsables et à apporter des réponses aux proches des victimes. Grâce à ces travaux, le groupe de travail et le comité exposent la réalité des disparitions forcées, qu'il convient de considérer parmi les plus graves et les plus dramatiques violations des droits de l'homme. Malgré cet engagement, malgré le soutien de plus en plus important de la communauté internationale, ces pratiques de disparition forcée sont encore fréquentes partout dans le monde, comme vous l'avez souligné dans le groupe de travail lors de la dernière session du Conseil des droits de l'homme. En 40 ans, près de 59 000 cas ont été portés à l'attention d'une centaine d'États, presque 700 pour l'année 2019-2020, et bien sûr, nous ignorons complètement le chiffre noir de disparitions forcées qui ne nous sont pas signalées. Ce constat est d'autant plus alarmant dans la période que nous traversons actuellement. La France déplore le fait que de nombreux cas de disparitions forcées sont commis et sont couverts par le contexte de pandémie de Covid-19. Comme l'a souligné le comité, dans certains pays, sous prétexte de lutte contre la pandémie, des corps sont brûlés sans identification préalable, sans information des proches, sans suivi, laissant les familles des victimes dans l'incertitude. Aucune circonstance, aucun prétexte, aucun contexte, quel qu'il soit, ne peut justifier cette pratique inhumaine. Chaque disparition forcée est un drame qui, au-delà des victimes elles-mêmes, affecte leurs familles, contraintes de vivre sans connaître le sort des proches disparus. Ce déni de justice et de vérité est inacceptable. Comme le disait Louis Joannet, qui nous a malheureusement quittés l'an dernier et dont le plaidoyer a largement inspiré l'élaboration de la Convention contre les disparitions forcées, la lutte contre ces pratiques est d'abord un combat juridique contre le temps qui passe. C'est ainsi qu'il résumait l'apport fondamental des articles 5 et 8, qui sont les véritables clés de voûte de la Convention. Cet instrument international a également permis le renforcement de la coopération pénale et l'entraide judiciaire, ainsi que la consécration par son article 24 du droit de savoir. Ces avancées majeures sont mises en œuvre concrètement. Elles devraient être garanties par le travail remarquable et complémentaire que mène le comité et le groupe de travail. L'action conjointe de ces organes permet en tout cas d'assurer un respect que nous espérons, que nous voulons croissant des dispositions de la Convention, permet de rétablir dans nombre de cas la justice et la vérité pour les victimes et leurs proches, et aussi de créer des canaux de communication entre les familles de personnes disparues et les États. Cette action, pour la France, elle s'inscrit dans le cadre d'une mobilisation historique au plan international. Nous avons été à l'initiative de l'adoption par l'Assemblée générale de la première résolution sur les personnes disparues et, conjointement avec l'Argentine, comme cela a été très bien rappelé 28 ans plus tard, de l'élaboration de la Convention sur les disparitions forcées. Mon pays est particulièrement fier de poursuivre cet engagement au sein du Conseil des droits de l'homme, où nous portons toujours la résolution pour le renouvellement du mandat du groupe de travail sur les disparitions forcées, avec l'Argentine, bien sûr, mais aussi le Japon et le Maroc. Depuis 10 ans, nous sommes mobilisés avec nos partenaires en faveur de la ratification universelle de la Convention contre les disparitions forcées. En 2013, nous avons lancé avec nos amis argentins une grande campagne internationale de promotion de cette ratification. Nous l'avons renouvelée en 2018. 63 États ont ratifié cette convention. C'est encourageant, mais c'est très insuffisant. C'est pourquoi nous avons décidé ensemble avec l'Argentine de lancer un véritable cycle de démarches conjointes pour la ratification de la Convention que nous mènerons sur les prochaines années en lien avec le groupe de travail et le comité sur les disparitions forcées, en lien avec les États affinitaires, les organisations internationales et la société civile. Nous savons que nous pouvons faire des choses supplémentaires pour favoriser les ratifications. Dans beaucoup d'États, particulièrement les plus petits ou les moins développés, administrativement parlant, ratifier une convention, c'est un travail coûteux, long et pénible. Et les parlements ont souvent autre chose à faire. Mais nous savons depuis une vingtaine d'années, avec les travaux d'aide à la ratification d'un certain nombre de conventions internationales, par exemple dans le domaine humanitaire, la Convention d'Ottawa sur les mines, mais il y a d'autres exemples. Nous savons qu'il y a des techniques que lorsqu'on arrive à réunir un tout petit peu d'argent, on peut financer une aide administrative, une aide technique, une expertise qui permet à un pays de ratifier dans de bonnes conditions, rapidement et sans avoir besoin d'exercer des pressions politiques qui en fait sont un peu inadéquates dans bien des domaines. C'est pourquoi c'est dans cette direction que nous voulons travailler avec vous tous. Chers amis, vous le savez, la France a fait son retour en tant que membre élu du Conseil des droits de l'homme le 1er janvier dernier. Ce mandat nous honore. Nous comptons, vous pouvez compter sur mon pays pour le mettre pleinement à profit pour renforcer la visibilité de la lutte que nous menons contre les disparitions forcées qui figurent au rang de nos priorités. Merci, cher Olivier. Merci à tous.
Merci beaucoup, Monsieur l'Ambassadeur. So I would like to warmly thank all the speakers for their participation and their statement, which I found personally extremely enriching. Just maybe a few remarks in conclusion. There were, I think, interesting remarks on what prompted the ratification. Of course, we all know that there is a need for political will at a certain moment, and sometimes for some political change when the political situation is not leading naturally to the ratification of the convention. For some states, there is the need to look back and to look back at the past. And for other states, they may feel concerned, even if they have not known the phenomenon of enforced disappearances in their past. They feel concerned by the situation of enforced disappearances in the world, and they want to participate in the global effort to eliminate that crime. And I also note the human factor. I mean, those individuals which within their government and within their national administration who are pushing hard and advocating the ratification of the convention. I think this is also sometimes a major contribution to this effort. About the process of ratification, I note that many speakers have underlined the importance of the involvement of civil society, and sometimes also the fact that when civil society does not get involved into the process, it does not really help. And also the crucial role and the central role, in fact, which is played by the families of victims at the domestic level, for pushing for the ratification and also taking the measures of implementation. Time and again, the working group and the committee have recalled that the victims of enforced disappearances are at the center of the efforts made globally to fight this crime. And there is certainly a need to continue to help the associations of families of the disappeared throughout the world to continue their advocacy effort. And I think currently there is not enough help, in fact, which is given to those associations and family, and there is really a call to all the governments to look at this issue more closely. There is, of course, a process of adaptation of the domestic legal system, which sometimes is hard, which sometimes is complicated, and we understood very clearly the example given by Norway. And sometimes I think there is a need for help, there is a need for assistance, there is a need for expertise, and that's maybe where the working group and the committee and all the experts which are also working on this issue of enforced disappearances, which have participated in the drafting of the convention, that's where maybe they can come in and help, maybe throughout some from seminars that could be held, be held at the domestic level. I note that in the chat, somebody was wondering about the help that some states can get from the United Nations, in particular the developing states which do not have the appropriate means to put in place all the instruments and to ratify the convention. I think there is a real need for a system that comes from the United Nations, but that could also be initiated by the states that have already ratified the conventions, that may be willing to also convey their good practices. And finally, I'm welcoming, of course, and I think in the name of all the members of the CED and of the working group, the announcement by the Secretary of Human Rights of Argentine and the Ambassador of France of a new campaign that will take place. And I note also Ambassador Vassou statement about the need also to find new ways to promote the ratification of the conventions. And of course, I can say that we as experts of the United Nations are always ready and at the disposal of the states parties to the convention to think about those new ways, those new means to be implemented to contribute to the ratification of the convention by the other states. So thank you again. And I hope you don't mind if we feel free to contact you again, all the participants that have gladly given your contribution to this discussion, if we contact you at the further stage to participate in other activities, maybe in other countries. So thank you very much again. I will now pass the floor to my friend and colleague Bernard Duhem, a member of the working group on enforced disappearances, to lead the way to the next panel. Bernard, you have the floor.
Thank you very much, Olivier. It's a pleasure to participate in this very important meeting. I'm also very thankful to the Academy, the colleagues of the committee, and the secretariat of both our institutions, as well as all the participants who are with us today and organizing this event, and all the participants. And I'd like also to thank Olivier de Frouville for chairing the previous session. So now we will address another very important issue, which is the national experiences. In other words, the perspectives of national human rights institutions and national NGOs in the ratification processes of the convention. As you know, the role of families in addressing enforced disappearances has been at the heart of the work of the working group and the committee. It's been at the heart of addressing the issue internationally, bringing the attention of the international community on this very important problem. Going back to the campaign that the families and the relatives did before the Human Rights Commission of the United Nations at the end of the 1970s and early 80s, we recall, of course, their fundamental role in the adoption of the resolution of the Human Rights Commission, which addressed enforced disappearances and, of course, created the working group on enforced or involuntary disappearances, of which I'm currently a member. At the heart of this resolution and at the heart of the mission of the working group is, of course, the humanitarian mandate of the working group, which is to help assist relatives and family members to establish a channel of communication with governments to try to obtain information as to the fate and whereabouts of the disappeared. So our working group was created thanks to the relatives. It was created for the relatives, and now it works with the relatives. So relatives, NGOs, human rights institutions play a crucial role in all of these processes, in particular during the process which led to the adoption of the convention, and in particular as well, leading to the adoption of specific provisions that address the needs and the rights of the relatives and the families, in particular the groundbreaking provision of Article 24 dealing with reparations. Now they play a crucial role in the ratification campaign, working with civil societies, families, and national human rights institutions governments need to address this issue by securing the ratification and then taking all the necessary steps to recognize the competence of the committee, and as well inviting the committee to come and observe the situation firsthand during a visit. When we went as a working group in 2015 in Sri Lanka, we were able to talk with relatives and civil society organizations which were pushing hard for the ratification of the convention, which occurred a few months later in 2016. We see today in Sudan the importance of the role of civil society in this process of ratification, which we celebrate and hope that the ratification process will be completed in the coming days. Also, the families play a crucial role in ensuring that states recognize all the relevant competence or jurisdictions of the committee, and we can see also, as addressed by Secretary Salinas, the importance of civil society in addressing the issue of recognition of the committee's competence on individual complaints in Mexico recently. Of course, families, relatives, civil society organizations, national human rights institutions also play a crucial role in the processes which lead to adoption or reforms of laws, as well as of administrative processes. The working group and the committee have always highlighted the importance of ensuring transparent processes which involve families, involve national human rights institutions and civil society organizations in these processes of adopting laws and processes in the process of implementing the convention. Today, we will look at the importance of the role of these institutions in the campaigns to promote the ratification of the convention and recognize the competence of the committee. We will look at experiences from the Balkans, from the Middle East, from Asia, and from Latin America. I would remind our speakers that they each have 7 minutes each, and that there is time for questions and answers after the end of this panel. During the next panel, we will try to sum up all of these questions. Our first speaker, I'm very glad to welcome her, is a colleague, a very good friend, Dr. Jasmine Jomo, who is the Human Rights Ombudsman of Bosnia and Herzegovina, and a former member and vice chair of the UN Working Group on Enforced or Involuntary Disappearances. She is currently a member of the UN Committee on the Protection of the Rights of All Migrant Workers and Members of Their Families. She was the first chairperson of the steering board of the Bosnia and Herzegovina Institute of Missing Persons, and a founder of the NGO Medica Zenica and the Center for Legal Assistance to Women, Zenica. Ms. Jomo, it's a pleasure to have you with us. Welcome. You have the floor.
Thank you so much. I really would like to thank organizers on this opportunity to speak on experience from Bosnia and Herzegovina related to ratification of convention, and also related to issue of enforced disappearances generally in context of Bosnia and Herzegovina. It is really a pleasure to be again in the same family as former member of the UN Working Group of Enforced Involuntary Disappearances. And it is a shame that we are not together now as usual practice and to share directly in person our experience and our knowledge. Searching for missing persons in Bosnia and Herzegovina is related, as you know, to the conflict from the period 1990 to 1995. In that period, more than 35,000 people disappeared. At least 7,547 people are still missing in Bosnia and Herzegovina. Today, when we mark 10 anniversary since the convention entry into force, it's good momentum to see position of this convention in BH as post-conflict society affected by enforced disappearances. This is particularly important to look from the perspective of the role of national human rights institutions and civil society. The civil society, particularly victims' associations, have been a promoter of all processes related to searching of disappeared persons in Bosnia and Herzegovina, do their intention to find missing relatives. This subjective element is crucial for all processes which have happened in Bosnia and Herzegovina related to enforced disappearances. Victims' associations met many systematic problems, including lack of access to information, lack of adequate legislation to regulate the area of missing persons, non-effective judiciary. By advocacy and pressure, they moved process from beginning, what resulted to adoption of the law on missing persons in 2003 and establishment of the Institute for Missing Persons. But searching process was very slow due to the fact that mortal remains were moved from primary to secondary and tertiary mass graves. The identification process by a classic method was inappropriate, and historical change happened in 2001 when DNA method has been starting to use in Bosnia and Herzegovina. We tend to ensure a strong legal base to push authorities to take adequate measures in searching their relatives, bring those responsible to justice, and ensure reparations for victims. Civil society organizations advocated ratification of the Convention on Enforced Disappearances. The result of this is that Bosnia and Herzegovina ratified the Convention on 30 March 2012. We will also have very soon, on the end of this March, our anniversary, 9 years anniversary. The ratification of the Convention has directed further action of civil society, particularly NGOs and the Ombudsman institution, the obligations which the state accepted by ratification. Those obligations require from the state to develop three main pillars: legislation, strong institutions, and clear procedure. The legislation interventions can be developed in different ways: particular legislation on enforced disappearances or interventions in existing legislation, or combination previous two models. Having in mind complexity of enforced disappearances issue, which requires multidisciplinary approach and the base of the experience from Bosnia and Herzegovina, there is no doubt that a combined model is the best. This means that a particular legislation on enforced disappearances should be established with focus on victims and their rights, including the right to truth and reparation. Parallel with that, there is necessity to ensure interventions in criminal legislation with the aim to define enforced disappearance as autonomous crime against humanity and is defined in international law without statute of limitation. Also, there is need to change family law, law on registry books, and laws on social and health rights. Related to the procedural criminal legislation, there are two crucial aspects. Detailed defining activity has humanitarian role, detailed defining procedure on searching missing persons as investigative activity due to the fact that this activity has humanitarian role to provide the truth for family. But at the same time, it is part of investigative activity in criminal process against perpetrator, and there is need to ensure support for victims as witness in court procedure. There are so many cases from Bosnia and Herzegovina which showed importance of this fact, because without, if we are focused only on the humanitarian role, there can be happened that everything, all evidences which are collected during of that process later can be unuseful in investigation or against responsible person. Achievement of truth does not mean only to find body of missing persons. It requires the truth about circumstances of enforced disappearance and the fate of disappeared person. A precondition for this is using of significant forensic technology, particularly DNA method, on identification, what was crucial in Bosnia and Herzegovina and whole Balkans region. Interventions in other pieces of legislation are related to prevention, that family relatives are obliged in court process disappeared person declared as missing what is so often precondition for access to some rights as pension, property, and ensure that relatives of missing persons are recognized as beneficiaries of social health and other rights. The experience of Bosnia and Herzegovina shows that recognition, particularly in the law, is most important issue for victims. There is open discussion. Does victims' status should be defined by one law regardless of the causes of damage, or is it better to have particular law for victims of enforced disappearances? I think that this issue should be defined among the international community, particularly between Committee Against Torture, Committee Against on Enforced Disappearances, because there is overlapping and with other committees. I think when we are speaking on victims from conflict, there should be one law which regulates status of all victims, and after that there can be particular chapters related to some groups of victims. When we are speaking on the role of national human rights institutions and NGOs, it is important to have in mind that their role in implementation of UN treaty bodies, and including CERD, is related to broad mandate of national human rights institutions, including reactive mandate focused on individual complaints and proactive to prevent human rights violations. Additionally, national human rights institutions are channel of communication between citizens and authorities, what gives them opportunity to collect relevant information from all spheres of life. The proactive role mandate requires from national human rights institutions to be present in society, monitor situation, and particularly promote international human rights standards as a way to prevent human rights violations. Annual and special reports which national human rights institutions present to parliaments, governments, and public, organization of trainings and other educational contents, building partnerships with civil society, particularly NGOs, media, academic community, are very useful activities in the promotion of human rights. The BH Ombudsman institution adopted platform for cooperation with civil society, signed memorandum of understanding with all universities in Bosnia and Herzegovina. But there is still need to improve this approach. All those activities are also very important for advocacy of implementation, the convention, which require from NGOs and national human rights institutions to have significant capacities. Therefore, it is not accidentally that UN treaty bodies, including CERD, have recommended to state authorities to ensure strengthening capacities of the Bosnian the Ombudsman institution and provide support to NGOs, particularly victims associations. There is a repetition of those recommendations in each periodic report of all treaty bodies, special procedures, and UPR. It is logically because national human rights institutions and NGOs are very relevant source of information for new and treaty bodies in process of state report revision, and without having them actively involved in this process, there is not possible to have a realistic picture of situation. BH Ombudsman institution regularly submit to UN treaty bodies own observations. Good practice is that this activity is also relevant in the process of accreditation of national human rights institutions under Gandhi. And I think that we need to strengthen this, that this parameter is very relevant, because through this parameter we can push more involvement of national human rights institutions in this process. It is obvious that UN recommendations that are critical point for enforced disappearance is the independence of judicial institutions. For what is crucial element is strengthening their capacities. This should include resource-enabled system of education and training and guidance for judges, prosecutors, and law enforcement officials. Development and acceptance of new legislation initiatives to ensure the further independence of judicial institutions, especially in context of Bosnia and Herzegovina High Judicial and Prosecutor Council, completion of the strategic and action framework related to judicial reform, development and implementation of formal procedures based on existing legal solutions. Procedures and resources for effective implementation of victims and witness protection are also required. In addition to this, treaty bodies have for countless years pointed to the issue of civilian victims of war. Special matters of concern are their rights to compensation and rehabilitation, and its implementation through domestic legislation, the recognition of sexual violence as war crime, and issues related to missing persons and enforced missing. Related to enforced disappearances, recommendations are required further strengthening capacities of Missing Persons Institute, support for families of missing persons, and the system for the collection of data related to missing persons and enforced disappearances have been used to address the issue of missing persons and enforced disappearances. In criminal legislation, enforced disappearance should constitute a crime, and in certain circumstances defined in international law, a crime against humanity. This requires the further steps should be taken with aim to strengthen the harmonization process of criminal legislation.
Sorry, we reached the time. Sorry, we have reached the time.
Okay, I will conclude. The recommendations of UN human rights mechanisms, particularly those related to enforced disappearances, should be seen as maximizing potential for the advancement of human rights in Bosnia and Herzegovina, and it deserves full exploitation. In order to achieve all of national human rights institutions and key human rights NGOs in the country need to perform a key role as the principal advocates of mainstreaming UN human rights recommendations in Bosnia and Herzegovina. Thank you so much.
Thank you very much, Dr. Jomo. It's always a pleasure. Thank you very much. Now I will pass the floor to Mr. Wadil Al-Asma, co-founder and president of the Cldh, the Lebanese Center for Human Rights, and co-founder and board member of FEMED, a very important organization, Euro-Mediterranean Federation Against Enforced Disappearances. Since 2015, he's one of the founders of the Lebanese social movement, Think, which actually participated in organizing and supporting most of the social demonstrations during the last garbage crisis in Lebanon. He's also actively participating in drafting several national laws of Lebanon, including the law related to those issues related to enforced disappearances. He's taken part in various initiatives to promote the ratification of the convention by Lebanon. Mr. Asma.
Thank you. Thank you very much first for inviting me. I will speak in French. Je voudrais vous remercier de m'avoir invité à cette rencontre pour les 10 ans de la création du comité de la Convention contre les disparitions forcées. J'aurais été ravi de pouvoir vous annoncer que le Liban a validé ou a ratifié la Convention, sachant que le Liban faisait partie des pays qui ont signé la Convention dès sa mise en signature. Malheureusement, l'exemple du Liban est assez étrange parce que nous avons là un pays, pour remettre un peu de contexte, où nous avons 17 000 disparus, des personnes qui ont disparu pendant la guerre qui a été au Liban de 75 à 90. Ces victimes de disparition forcée, ce ne sont pas des missing, ce ne sont pas des personnes qui sont perdues dans la nature ou qui sont morts dans un accident ou dans un attentat. Ce sont des gens qui ont été enlevés, que ce soit par des milices armées ou par des forces armées militaires, que ce soit l'armée israélienne qui occupait le Liban ou l'armée syrienne. Nous pensons toujours qu'il y a une petite centaine, ou à la limite un peu plus qu'une centaine, qui étaient vivantes en Syrie, dans les prisons syriennes dans les années 2011-2012. Depuis, effectivement, la situation en Syrie est assez catastrophique pour que nous puissions plus avoir de nouvelles. Et donc, dans ce contexte-là, voilà un pays qui a signé la Convention, qui ne l'a pas ratifiée. Et là, c'est assez rocambolesque, je voudrais dire, parce que le gouvernement libanais, en 2007, a demandé au Parlement de pouvoir ratifier la Convention, l'autorisation de ratification. Et cette demande est tombée dans un imbroglio constitutionnel parce qu'au moment où la demande a été effectuée, le Parlement ne reconnaissait pas la légitimité du gouvernement. Alors, je ne sais pas si Salam Saïd Ahmed, qui à l'époque était représentant du haut-commissaire au Liban, avait suivi avec nous ces péripéties. Et donc, depuis maintenant 13 ans, ça passe vite, la demande de ratification est coincée. Le Parlement dit ne l'avoir jamais reçue et le gouvernement dit l'avoir déjà envoyée, ne pouvant pas la renvoyer. Et nous avons essayé pendant des années, nous continuons à essayer, à trouver un moyen de faire sortir cette convention des méandres administratifs. Malheureusement, ça ne marche pas. Je ne sais pas si on va dire le groupe d'États avec la France, qui ont une influence au Liban, qui travaille sur la ratification de la convention, peut convaincre les autorités libanaises d'être un peu plus pragmatiques dans leur approche à la ratification de la convention. Surtout que le Liban, il y a 2 ans, et à part les efforts d'organisations nationales et internationales de défense des droits humains, a ratifié ce que je pourrais qualifier une des lois les plus avancées en termes de lutte contre les disparitions forcées. Donc nous avons une loi qui pas seulement parle de la création d'une commission indépendante pour les disparitions forcées. Malheureusement, c'est sur le papier. La commission qui a été créée a tous les critères sauf l'indépendance, mais surtout, il criminalise la disparition forcée. Il y a un article dans la loi qui reprend un peu le principe de criminalisation des actes de disparition forcée. Malheureusement, comme toujours au Liban, ça a été voté, mais nous n'avons pas encore réussi à le faire appliquer. Et donc, si je voulais revenir à la question de la convention, moi je voudrais dire, même si le Liban a une loi qui, même sur certains niveaux, va au-delà de ce que la convention, dans la définition de ce que c'est une victime de disparition forcée, dans la criminalisation de la disparition forcée, dans la protection des victimes de disparition forcée contre tout accord ou on va dire, toute décision qui les priverait d'avoir recours à la justice. Mais reste, c'est une loi locale et nous pensons que ceci n'empêche pas le Liban, ne devrait pas empêcher le Liban ou d'autres pays de ratifier la Convention internationale, parce que ça apporte, surtout avec la reconnaissance du comité, de la compétence du comité, ça apporterait une protection supplémentaire pour les victimes de disparition forcée. Ça constituerait, et ça c'est plus important pour nous, ça constituerait une barrière supplémentaire à toute personne qui, dans le futur, pourrait penser à pratiquer la disparition forcée comme une arme de guerre, comme ce qui se passe en Syrie à côté de nous, où malheureusement la disparition forcée est devenue une arme de guerre et de contrôle de la population, avec des dizaines de milliers de victimes de disparition forcée. Et on ne peut pas délier ou dissocier les deux cas, parce que nous recevons au Liban un grand nombre de réfugiés syriens, et dans mon organisation, nous recevons énormément de victimes qui ont perdu ou qui ont une personne ou plusieurs personnes de leur famille victimes de disparition forcée. Pour conclure et ne pas dépasser le temps, je pense qu'il est important qu'au niveau du comité d'insister sur les pays qui ont signé et qui trouvent des prétextes, parce que vous savez bien que je ne pense pas qu'il s'agit que d'une question administrative ou bureaucratique. Je pense que le gouvernement libanais est inquiet de rajouter ou de signer, de ratifier cette convention parce qu'il y a cette question de 17 000 disparus qui est toujours en suspension, malheureusement. Les familles attendent toujours de savoir, il y a quelques jours, il y a aujourd'hui ou hier, une des mères de disparus de la guerre est décédée en attendant d'avoir de nouvelles de ses enfants, et elle n'est pas la seule. Tous les mois, tous les jours, on entend parler de familles qui perdent un parent et qui est souvent le dernier espoir pour retrouver ou pour pouvoir identifier les corps s'il y a des corps qu'on trouve, ou pour accueillir les disparus s'ils reviennent de détention. Et donc, nous pensons qu'il est important d'insister, de continuer régulièrement à demander aux États où ils en sont au niveau de les ratifications. Nous faisons ceci en interne, au niveau local, mais je pense qu'il est important que le groupe de travail sur les disparitions forcées et le comité contre les disparitions forcées aussi sollicitent et interrogent le gouvernement libanais. Et pourquoi depuis 13 ans Cette convention, elle est signée, mais elle n'est toujours pas ratifiée. Et je vous remercie de m'avoir donné l'occasion d'intervenir.
Merci beaucoup, Monsieur Asmar. Thank you very much for this important presentation on the situation in Lebanon. Without further ado, we will now welcome Mugianto, who is a former chairperson of the Indonesian Association of Families of the Disappeared and of the Asian Federation Against Involuntary Disappearances, AFAD. He was among the first to bring cases of disappearances in Indonesia to the UN in 1998. And since then, he got involved in advocacy on the theme of enforced disappearances within the United Nations. As then chair of AFAD, he was also involved in the lobbying efforts for the ratification of the convention in a number of Asian countries. Signed the convention in the Ministry of Foreign Affairs in Paris. Mugianto himself is a survivor of enforced disappearances, which occurred before the fall of Indonesia's dictator Suharto in 1998. He currently serves as an advisor on human rights at the Executive Office of the President of the Republic of Indonesia. Mr. Mugianto, you have the floor. Thank you very much.
Thank you very much, moderator, friends and colleagues. First and foremost, I would like to thank to the Committee on Enforced Disappearances, UN Working Group on Enforced Disappearances, and the International Coalition Against Enforced Disappearances for inviting me to participate in this important and timely webinar. As requested, I will be sharing Indonesian experience in the process of signing and hopefully soon the ratification of the UN Convention on Enforced Disappearances. But before that, please allow me to very briefly give you a historical context of the systematic practice of disappearances in Indonesia. I would like to have Ms. Jasmine with the PowerPoint presentation. Thank you very much. Can we have the next slide, please? Dear friends, in a report submitted by Manfred Novak, independent expert in charge of examining the existing international criminal and human rights framework for the protection of persons from enforced disappearances in 2002, it was written that enforced disappearance, I quote, seems to have been invented by Adolf Hitler in his Nacht and Nebel Erlass, Night and Fog Decree of 7 December 1941. The phenomenon reappeared as a systematic policy of state repression during the late 1960s and early 1970s in Latin America, starting in Guatemala and Brazil. End quote. Indonesia, unfortunately, is not an exception. In the pretext of eliminating the communists, thousands of people were murdered, imprisoned without trial, tortured, including being subject to enforced disappearances in 1965 until 1967. The practice unfortunately kept happening even after the fall of the dictatorship in 1998, when there were armed conflict in some areas in Indonesia early 2000. Next slide, please. Friends and colleagues, for the last 22 years, the democratic government of human rights in form of systematic and widespread practice of enforced disappearances. Knowing the truth about the whereabouts of the disappeared, putting responsibilities, and recurrence and CSOs to the government. The engagement of civil society organizations with the state institution have been very dynamic, yet productive. Some progress achieved. Most importantly is the report of the inquiry of the National Commission on Human Rights in 2006, which concluded that there is a commission of gross violation of human rights in form of enforced disappearances of activists in 1997 and 1998, and recommended that the government to establish human rights court find the disappeared person, provide reparation to the victims, and ratify the Convention on Enforced Disappearance. I would also share here that Indonesia has a working local Truth and Reconciliation Commission in Aceh, one of province in Indonesia. In a public hearing on cases of enforced disappearances held in 2019, the families of victims expressed their hope that what they experienced will never happen again anywhere and hope that the government ratify the convention. Friends and colleagues, in September 2010, Indonesia signed the Convention on Enforced Disappearances due to the continuing pressure of CSOs and victim groups, as well as a recommendation by the National Commission on Human Rights, UN bodies and mechanisms, regional NGOs such as AFAD and ICAT. And then in 2013, the previous president of Yudhoyono in Indonesia submitted the document of ratification of the convention to the parliament for deliberation and adoption. In Indonesian legal system, ratification of an international treaty should be done by both executive, the president, and legislative body, the parliament, in form of law. However, after deliberation in the parliament, some political parties in the parliament expressed their position that they need more time to further study and discuss the convention. So until the term end in 2014, the parliament did not approve the proposal for ratification. And because the process cannot be carried over from the previous to the next term of the parliament, then the current administration should start from the very beginning. Can I have the next slide, please? In this process, I would like to acknowledge the contribution and role played by our Latin American and other friends from abroad. The late Patricio Reis, the former coordinator of ICAT, Tati Almeida, and Aurora Morea of Las Madres de Plaza de Mayo, Patricia Isasa, a survivor of torture from Indonesia, Rus Lanos and Nila Heredia of FEDEFAM, Irina Krasovskaya from We Remember Belarus, Gabriela Citroni, at the time the advisor of ICAT from Italy, Jeremy Sarkin from the working group, and friend from FEMET came to Jakarta to help us and meet our government on the importance of the convention based on their experience.
Sorry,
not to mention here,
time is over.
Okay, not to mention is friend from AFAD, especially the former Secretary General Eileen Bacalso, who is with us today, who visit us more than 2% of time. So the current President Joko Widodo administration has expressed its commitment that the government will ratify the convention this year. This is also for the purpose of completing the whole 9 core human rights convention, 8 of which are already being ratified by Indonesia. For this purpose, the Ministry of Foreign Affairs and the Ministry of Law and Human Rights have prepared the document of ratification to be soon submitted to the Parliament. The CSO coalition for the ratification of the convention have also conducted series of lobbies and meetings with those ministries, including with my office, the Executive Office of the President, urging the government to expedite the process of ratification. For some section of the government, there might still be some burning issues related to the content of the convention, such as the retroactivity, competence of the committee, possible reservation and declaration, and others. But the good thing in Indonesia is that there has been regular, frank, and positive communication between CSO and the government on the matter. And most importantly, Indonesia all agreed and hope that Indonesia should already be a state party of the convention this year. Last but not least, I believe that the support and cooperation from international community, push the CSO to the actor at the national level is imperative to have disappearances ended by first having the state to ratify the Convention on Enforced Disappearances. I thank you very much, moderator.
Thank you very much, Mugianto, for this very insightful presentation on the experience in Indonesia. Moving now to Latin America, we will welcome Grace Fernandez, who is the sister of Dan Jeremil Fernandez, who was forcibly disappeared in Coahuila, Mexico in 2008. She has a degree in public accounting from the University Autónoma del Noreste and is a specialist in human rights with a focus on victims' rights. As the Buscami organization and the movement for our disappeared in Mexico, she has participated in the construction of public policies related to the search for the disappeared persons and to the attention to victims and their families. She's the co-coordinator of the National Citizens Council of the National System for the Search for the Disappeared Persons. Together with the movement of Our Disappeared in Mexico, she took active part in the campaign to promote the recognition of the competence of the committee to examine individual complaints. Thank you, Ms. Fernandez, for being with us this morning. You have the floor. Thank you.
Gracias, Bernard. Quiero agradecer al comité, al grupo de trabajo y a la Coalición Internacional contra la Desaparición Forzada por este espacio. Quisiera platicarles un poco sobre cómo fue la incidencia, más allá de la ratificación de la convención. Algo que es sumamente importante para nosotros es la ratificación del artículo 31 de la convención, que faculta al comité a poder recibir comunicaciones individuales. ¿Y por qué en ese sentido? Porque si bien en el 2008 se ratificó la convención, a partir del 2000 tuvo competencia el comité, al día de hoy no ha podido venir de visita a México para poder conocer en campo, en el terreno, qué es lo que está sucediendo con respecto a la desaparición de personas. Hay más de 83,000 personas desaparecidas. Si bien en el 2018 entró en vigor la Ley General en materia de desaparición, la realidad es que cada día sigue incrementando el número de desaparecidos. En el 2015, el comité le pidió al Estado mexicano que hiciera un informe sobre la situación de las desapariciones. A raíz de ese informe que el Estado mexicano, pero que también la sociedad civil en este ejercicio de informes alternativos que se pueden presentar, el comité emitió 14 recomendaciones. Digo, grupo de trabajo, y hay que hacer también mención de esto, en el 2011 hizo una visita in loco. Eso permitió que pudieran hacer este estudio, investigación en el campo, que tuvieran acercamiento no solamente con el Estado, sino también con los grupos de víctimas, que ya veníamos posicionando estas discrepancias de lo que decía el gobierno que estaba haciendo y lo que realmente sucedía. En el 2015, entonces, surgen estas 14 recomendaciones del comité, y para las familias, junto con las recomendaciones que hizo sobre la visita a grupo de trabajo, las juntamos porque al final muchas de ellas eran reiterativas en el sentido de la necesidad de tener un registro nacional, de tener una ley en la materia, de hacer persecución e investigación y algunos otros temas que, digamos, fueron la agenda mínima, el estándar mínimo que retomamos las familias para poder hacer la exigencia hacia el Estado de esto es lo que hay que hacer, y no porque yo lo crea que sea necesario, es porque la comunidad internacional que tiene experiencia en esto está validando que efectivamente esto es lo que se necesita para atender de una forma efectiva. Lamentablemente no había demasiadas condiciones. Aún con eso, las familias impulsamos la adopción de estas recomendaciones. Pero veíamos justo la necesidad de que el comité pudiera recibir las comunicaciones individuales, que son lo que permiten que puedan analizar qué sucede, por qué las investigaciones no avanzan, por qué las instituciones del Estado mexicano no tienen un resultado ante los grupos criminales, ante la macrocriminalidad, ante la corrupción que es lo que permite y facilita las desapariciones hoy en día, aún hoy en día en México. Entonces, nos dimos a la tarea desde el Movimiento por Nuestros Desaparecidos en México, pero también desde otros espacios colectivos, de buscar la incidencia para la ratificación del artículo 31. Para esto lo que hicimos fue identificar quiénes serían nuestros actores clave, nuestros aliados en esta lucha. Al venir el cambio de gobierno que sucedió en el 2018, apareció, digamos, en este escenario de nuevos funcionarios, por ejemplo, el subsecretario Encinas, la secretaria de Gobernación Sánchez Cordero, que tomaron la bandera de las víctimas para empujar la agenda de derechos humanos, pero más aún específico de las desapariciones. Si bien traíamos un compromiso presidencial de aceptar la ayuda internacional, pues había que bajarlo a la aceptación de los instrumentos que realmente puede dar facultad a los organismos. Entonces empezamos a buscar reuniones con la secretaria de Gobernación, con el subsecretario, pero también con senadores, porque a final de cuentas el Congreso mexicano es el que tiene que autorizar que el Ministerio del Exterior pueda aceptar la competencia. Entonces empezamos a acercarnos a esos actores, pero definitivamente algo muy importante cuando te topas con la resistencia al interior de los gobiernos, como en nuestro caso el Ministerio del Exterior, donde decía, pues primero justifícame que realmente es de utilidad invertir tanto tiempo y tantos recursos en un instrumento que no veo cómo sea el beneficio. Ahí fue donde nosotros ejemplificamos con las recomendaciones de grupo de trabajo, con las recomendaciones que ya había emitido el comité, y decíamos, si solamente el comité, con una vista de lo que tú le dijiste y de lo que las organizaciones pudieron expresar, tuvieron la capacidad de decirte esto, imagínate la capacidad de fortalecimiento institucional que puedes tener para poder, a partir de la revisión de los casos individuales. Entonces, lo que hicimos fue buscar a la sociedad civil, buscar a aquellos que no tienen una víctima desaparecida y decirles, ayúdanos, apoya, firma, redes sociales, solicitudes en línea, solicitudes físicas, y presentamos más de 120,000 firmas junto con nuestra solicitud de tenemos más de un año, cerca de un año esperando la ratificación. Aquí solamente quiero mencionar que, pues a final de cuentas, la voluntad política es una conquista de la voluntad ciudadana. Si las víctimas, organizaciones y sociedad civil se unen para impulsar al mismo tiempo, es difícil que el Estado pueda negar la legitimidad. Pero también es claro que hay que hablar con el Estado y que entiendan que es un problema de Estado, no es de una sola institución. Y eso se repite no solamente en México, sino en toda la región, ¿no? En donde vemos que lamentablemente hay solamente una institucionalidad luchando y que no hay un seguimiento a las recomendaciones, a las sentencias de los organismos internacionales que realmente permeen en lo que es la institucionalidad que debiera estar dando resultado.
Ya se acabó el tiempo.
Sí, ya solamente cierro diciendo que para el caso mexicano lo más importante fue eso, el apoyo de la sociedad civil y no quitar el dedo del renglón, porque hay que estar impulsando al Estado. Gracias.
Muchas gracias, Grace Fernandez. Thank you very much. So unfortunately, I will not be able to do a synthesis of all the presentations, but I wanted to thank every one of you for this very important contribution to not only this event, but of course to the campaign for ratification and then to the full implementation of the convention. I will now pass the floor to my colleague and friend, Luciano Hassan, who is also a member of the working group and former member of the committee, who will now moderate a period of question and answers. Thank you. Luciano, you have the floor.
Thank you very much, Bernard. I just want to say, just to salute this initiative by ICAED, of course, together with the Secretariat of the Working Group and the committee and the members. But what I want to say is that the families of the disappeared have always pushed for most important steps in the fight against enforced disappearances. So this campaign for ratification is also very important, and the role of the families is always the most important thing. But of course, it is the key is that the states interact between themselves and cooperate to have these ratifications worldwide, as enforced disappearances are spread worldwide also. Also thanks to the Geneva Academy. We don't have much time. We have less time than we have expected. So what I will do is just to only post a few of the many questions that were done by the chat. And there were also a lot of comments. So thanks a lot to all the participants for these important comments. There were some answers in the chat also. So what I will do is to read a few of these questions, asking to some of the participants to answer later. What I ask is to answer very concretely, maybe in 1 or 2 minutes each. And I also would ask some members of the committee and the working group that are here with us also, maybe because many of the questions were in a way directed to us, to the members. So if, for example, Olivier, I will ask a few questions to you, and maybe if there are other colleagues from the working group or the committee willing to answer some of the questions, please let me know by the chat, and I will give you the floor. So first of all, there was a question from Jenny Espino to Horacio Pietragala, the Secretary of Human Rights from Argentina. She asked about which recommendations would you make to Spain regarding the disappearance of children? Do you consider the appropriation of babies in enforced disappearances? So Horacio, I will give you the floor later to this question. There was a few questions to Undersecretary Encinas from Mexico. One was, for example, from Mariano Machain, who asked the Undersecretary which are the main challenges to implement in Mexico the recommendation of the committee, including many urgent actions. And there was also a related question from Luis Abarca, also to Undersecretary Encinas, about the lack of responses in the attention to victims. So if you would like to comment on the policies of the state to support victims. I actually would like to ask a question to Elin Winstein. The convention establishes obligations on cooperation between states, for example, in criminal investigation, for the search, on extraditions. So the question would be, do you think that could be a special value for those countries that have ratified the convention but are not having special problems of enforced disappearances in their own country, this issue of cooperation, that it could be a good thing to the fight against enforced disappearances worldwide. Then it was a question from Amina Hanhua to Olivier de Freville. It was about the possibilities of a follow-up visit to Pakistan. Maybe that's a question that we can answer from the working group. So what I can say, that is something that is public, is that the working group asked for a follow-up visit. So I think that question could be answered like that. Then I'm not sure if Bernard is still here, but there was a question on how closely linked is migration to the issues of enforced disappearances. And what I can tell you, if Bernard is not with us anymore, is that the working group has presented 3 years ago a report on enforced disappearance of migrants. So that is a public report that I can refer you to that. That could be a beginning for that problem. I mean, to work with that problem. Then it was a question about from Lavinia, if does a submission to the working group excludes an application to the European Court. I just would answer that question saying that no, because the working group is not of a similar nature of the European Court, but maybe one of our European colleagues could later answer on that. Then Randolfo Sandoval from Honduras asked how the committee can help state parties to adopt public policies in the framework of the convention. Maybe that's a question that you, Olivier, could answer in 1 or 2 minutes. Then Claudia Campo from Colombia asked how can international community support the work of Colombian civil society organization or activists to fight for the search of the disappeared and for the truth. Maybe one of our colleagues from the committee or working group would like to answer that question. Please let me know. And finally, Rodrigo Gomez Tortosa from ICAED asked to the members of the committee and the working group if the virtual sessions that we are carrying since the beginning of the pandemic 1 year ago can facilitate a better contact with families and organizations. So these are, in a way, most of the questions. So I will give the floor to Horacio Pietragala to answer the first question. Please, Horacio, if you can answer as quick as possible, maybe in 1 minute, you have the floor. Gracias.
Perfecto. Bueno, respecto al franquismo y a los bebés robados en la República de España, la verdad que primero dos temas. Hay ONGs trabajando ya en España, están en contacto con las asociaciones Abuelas de Plaza de Mayo en Argentina, pero también el Estado argentino tiene la Comisión Nacional por el Derecho a la Identidad. Esto depende de la Secretaría de Derechos Humanos, es un ente descentralizado, es una comisión que trabaja en este sentido y junto con Cancillería Argentina se brinda información y asesoramiento a las distintas ONG de España para poder llevar adelante su búsqueda. Bueno, nosotros tenemos varios contactos con ONGs de España, por ejemplo, SOS Bebés Robados, que es una ONG de Cataluña, donde denuncia el robo de bebés. Hay 2 carriles en la temática de robo de bebés en España. Uno es, porque ahí me preguntaron si se podían declarar delitos de lesa humanidad. Yo creo que cuando el delito se comete con un plan sistemático, como se comprobó en Argentina que hubo un plan sistemático, que eran hijos de opositores políticos a las personas que llevaron adelante el plan de robo de bebés, claramente estaba enmarcado en maternidades clandestinas, donde las mujeres daban a luz en forma clandestina, esas mujeres después eran asesinadas y desaparecidas, y sus bebés, hubo también mujeres embarazadas que fueron asesinadas, fueron las menos, pero sus bebés nacidos en estas maternidades clandestinas, fueron entregados a familias vinculadas a militares, robándole cualquier posibilidad de conexión con su verdadera historia. Esto es lo que nos pasó a muchos de los hombres y mujeres que fuimos apropiados en ese momento de la dictadura. En este marco yo lo veo como un delito de lesa humanidad claramente, y hay una desaparición forzada porque, bueno, son las fuerzas de seguridad que cometen esta aberración para desvincular cualquier relación de ese bebé con su familia y obvio con su historia y con sus desaparecidos. En España, al principio del franquismo, hubo casos similares donde fueron asesinados sus padres y sus bebés fueron arrancados de los brazos de su madre y entregados a familias de bien, entre comillas lo digo, o a la Iglesia mismo, que la Iglesia tiene una complicidad tanto en las dictaduras de Latinoamérica como también en lo que pasó en el franquismo, y con esto termino, pero después en España hubo un mecanismo donde los bebés robados eran a través de los hospitales públicos, de las clínicas de España, donde ya la práctica estaba habitualizada, digamos, era habitual, donde una mujer pobre tenía hijos, tenía dos, capaz que le robaban uno, le decían que era uno solo, o que se había muerto bebé, y la mayoría de las consultas que nos llegan es porque el esquema entre la Iglesia y la corporación médica en España, había un negocio ilegal atrás de eso, donde hubo mucho robo de bebés. Yo creo que son dos carriles distintos, cuando está el Estado, digamos, en el tráfico de bebés, es un tema, y cuando hay una persecución a opositores políticos y a través de esa oposición, esa persecución política se le roba los bebés a los opositores políticos, creo que ahí sí había claramente una desaparición forzada. Es muy difícil separar esto en un momento de dictadura como el que se vivió en el franquismo en Francia, pero creo que tiene esa dificultad, ¿no? Que había un esquema armado con la Corporación de Salud y la Iglesia donde se robaban bebés. Y por otro lado, lo que pasó en el inicio del franquismo, donde los bebés de los militantes políticos, que eran opositores o que eran primero, defendían una república en España, bueno, fueron también perseguidos y que les robaron su bebé, muy similar a lo que pasó en Argentina. Dos carriles distintos, la materia, no soy experto en la materia para decir si el tráfico de bebés son delitos de desaparición forzada, pero sí en un marco de dictadura y de persecución política, claramente fueron desapariciones forzadas.
Many thanks to Horacio Petragala. I'm sorry that we are very short in time. So I will give the floor to Undersecretary Encinas. Please, Mr. Undersecretary, you have already answered a few of those questions. So if you can maybe take 1 or 2 minutes.
De manera muy puntual, particularmente a los señalamientos de Mariano Machain, hay que señalar que se ha dado respuesta puntual al informe que emitió el Comité de Desaparición Forzada en el 2015. Pongo 3 ejemplos muy puntuales. Uno, la exigencia más enérgica, que fue el reconocimiento de la competencia del Comité de Desaparición Forzadas y particularmente el caso vinculado con el tratamiento de comunicaciones individuales e interestatales. El segundo, el que se refiere a la elaboración de una legislación en materia de desaparición forzada y desaparición cometida por particulares, que fue emitida en el 2017, donde se tipifica como un delito grave, como una violación grave a los derechos humanos, la desaparición forzada, y donde se nos plantea también la necesidad de hacer un registro nacional de personas desaparecidas y no localizadas en el país, que actualmente se actualiza en línea y todo el mundo tiene acceso a él. ¿Cuáles son los principales retos? Yo creo que los principales retos están hoy en la implementación de la justicia y en el cumplimiento por parte de los distintos órdenes de gobierno, particularmente de los gobiernos de los estados de la República, para atender todas las acciones de urgencia que se plantean y particularmente que se cumplimente de manera puntual la persecución de este delito. Muchas gracias.
Many thanks, Undersecretary. I would give the floor to Elin Winstein. Maybe if you can also share with us a few thoughts on the question.
Can you?
Do you
hear me now? Do you see me and hear me?
Yes, I can hear you now.
Yeah. So the question was whether the provisions concerning mutual legal assistance can be some obligations important also for states where enforced disappearance is in principle not a problem. And the answer to that must of course be yes, because as the Convention establishes obligation for states in this domain. that having been said, Norway didn't need any legal changes to comply with the convention in this regard, and certain states like Norway don't need, for instance, a treaty obligation to extradite or provide mutual legal assistance. So we would be able to do that in concerning also the crimes of enforced disappearances without the convention. But of course, the convention establishes important obligations, such as you either extradite or you prosecute somebody who is responsible for enforced disappearances. So my answer to the question will be that I guess that it will have could have importance, but to my knowledge, we have no experience with this kind of mutual cooperation based on the convention.
Thank you very much, Elin Winstein, for this answer. So I will give the floor to Olivier de Froville. Maybe Olivier, you can respond as a member of the committee some of the questions, and also as a former member of the working group. So if you can maybe in 1 or 2 minutes also respond to some of those questions.
Thank you very much, Luciano. But I think on Pakistan you responded, and this is up to the members of the working group on Pakistan to continue on enforced disappearances, to continue the effort. There has been a follow-up report in 2016 by the working group, and I know that the working group has put a request for a follow-up visit to Pakistan. So hopefully this will happen. On Honduras, I just wanted to mention the fact that the situation of Honduras, which has ratified the convention, is followed up very closely. There has been concluding observations in 2018. Honduras has handed down a report on a follow-up on 3 questions which had been chosen by the committee in 2019, and Honduras is to also table its report under Article 29.4, paragraph 4 of the Convention, so as to give further information, additional information on the implementation of the Convention by June 2021. So I hope that the government of Honduras has now contacted the civil society, the families associations, the relatives associations in the process of preparing this report before the committee. Thank you very much.
Thank you very much, Olivier. I think that we are running out of time. So maybe I can give the floor. Sorry that we could not respond to all the questions, but maybe we can use the chat for that, like Alban is suggesting for the last part of the meeting. So I will give the floor to my colleague of the committee, Horacio Ravena, to present the next panel, the third panel. So thank you very much for these very interesting questions and comments.
Thank you, Luciano. This meeting is too long, and then I ask all the speakers of our panel, please make an effort to speak no more than 7 minutes, so it will be possible to participate with questions in the next panel. Dear participants, we are now going to address another aspect of the ratifications campaign related to the role of the international NGOs and networks. Lots of initiatives have been taken, and the idea is that we can learn from this experience, taking lessons learned and thinking as to the way forward to improve our strategies and think on the way to cooperate. We are going to start with the intervention of Ms. Alice Edwards, who will present the experience of the promotion of another international treaty of the UN, the Convention Against Torture. The Convention has 171 ratifications, a large success. The experience gained by this treaty is therefore of much relevance for us all to think ahead of what to do to promote the ratification of our convention. Dr. Alice Edwards is head of Secretariat of the Convention Against Torture Initiative, a position she has held since January 2016, providing strategic and policy advice to the 6 CTI core states and acting as the primary facilitators of CTI's year-round program of activities. The aim of the convention intervention is to reduce and prevent the risk of torture and ill-treatment through the universal ratification and implementation of the UN Convention Against Torture by 2024. Previously, Dr. Edwards worked at the UN High Commissioner for Refugees, including in Bosnia and Herzegovina, Morocco, and Rwanda. She also worked within the NGO sector in Mozambique and Amnesty International in London. She has also held academic appointments in law at Oxford and Nottingham universities, and continues to teach in a program of international law at Oxford. She is widely published and cited, with over 30 publications, and is an Australian qualified barrister and solicitor. Ms. Edwards, you have the floor.
Thank you very much, Mr. Ravena, and fellow panelists and participants. Noting the time, I am going to try to reduce my presentation to just really highlighting some of the lessons we have learned over the last 7 years with the CTI, the Convention Against Torture Initiative. So, and I think it's quite timely and important also to hear about the Convention Against Torture campaign, because I do see the ICED as a sister treaty to UNCAT, and they have a lot of alignments, as you know. So first I'd say that CTI, the reason for its success, and just to give you the figures, we have had 17 new ratifications since we started in 2014. And that means we are tracking above the average of the other human rights treaties. In 2020, in the COVID year, UNCAT ratifications made up 1/3 of all the human rights treaty ratifications. And we're only surpassed by the Convention on the Enforced Disappearances, which is tracking at 22 over the same period as CTI, and also the rights of persons with disabilities being the two newer treaties. So I think the success of the CTI so far, we can attribute to the fact that it is a state-led initiative created by states and for states to encourage not only universal ratification of the convention, but also full implementation. And I think that's one of the main messages today, that any campaign should deal with ratification, implementation, and reporting. There are 6 governments behind the initiative, 1 from each strategic region. So it varies from the usual group of friends. This is actually an initiative with a group of friends in addition. And now we have currently 42 governments that are part of the group of friends, as well as almost all the leading anti-torture NGOs, international organizations, regional organizations, and leading experts. I'd say the second main reason why it's been successful so far is because of the principles upon which it is based. And essentially, we are a constructive organization, constructive dialogue, no name, no shame. And this has been very effective when we talk about sensitive issues around torture and ill treatment. We work through a peer-to-peer format and through often regional, but also global mechanisms. And the aim is to inspire other states to take action rather than to prescribe or to condemn certain behaviors. So we kind of fit in this nice gap between the advocacy, the stronger advocacy campaigns and the condemnation, for example, from NGOs and the UN through states and their clear diplomacy. We fit in this nice gap, and we've been able to capitalize on that. I think also we're time bound. We are a 10-year initiative, and I think that gives everybody a focus and a time frame. The states decided that they needed a secretariat to be able to support the capacity building and technical work we do, and we have an annual program of activities that we run, which includes regional capacity building events, study visits in Geneva, and country delegation visits at the invitation of governments, as well as awareness raising. And we have recently released a whole range of tools and guides, which are in multiple languages and in a resource database. Yes, am I going too fast?
No, you have 1 minute more, please.
Okay, lovely, good. So I also think the other important point is that we are fully funded, and all of the core states contribute both financially but also in-kind contributions, their expertise and their time, both Geneva, New York missions, also through Capital and through their embassies abroad, supporting these efforts. And I would say that I think the most important lesson in terms of the practicalities are really around coming up with responses to governments' concerns and challenges around ratifying the convention, having ready-made answers that can also be tailored to those countries' particular experiences. And we go beyond human rights arguments, but also the wider benefits of ratifying the convention, for example, efficiency and fairness in the justice system, political stability, economic development. We do work on the SDGs, reputational and the value of a country's reputation, as well as linkages with the corruption campaign. So I think with that, I will conclude there so my other dear panelists can also share their experiences. Thank you very much, Chairperson.
Thank you very much, Madame Edward. Thank you for your effort and for your time. Well, now it's an honor for me to present Mary Eileen Bacalso. She was a young activist when I had the pleasure to meet her last century at the FEDEFAM event. She is the current president of the International Coalition Against Enforced Disappearances. She served as Secretary General of the Asian Federation Against Involuntary Disappearances for 21 years. During these years, she actively participated in the drafting process of the convention. By dint of her work against enforced disappearances, she was awarded the Emilio Mignone International Human Rights Prize in 2013 by the government of Argentina, the Patrick Rice International Human Rights Award in 2013 too by the Torture, Abolition and Survivors Support Coalition, and the Franco-German Ministerial Prize for Human Rights and the Rule of Law in 2019. I present a high personality of human rights, but especially to my dear friend, Eileen. Please, Eileen, you have the floor.
Thank you very much, Horacio. I was actually asked to reduce the presentation from 7 to 3 minutes. I'll see what I can, because I received a lot of requests from members to include the situations in the respective countries, but I'll try my best. Greetings from ICAED. At the outset, I would like to acknowledge the Latin American Federation of Associations of Relatives of Disappeared Detainees, which in its first Congress in Costa Rica in 1981 dreamed of and conceptualized a convention, a treaty, a global treaty against enforced disappearances. 3 decades later, we now have the International Convention for the Protection of All Persons from Enforced Disappearance, ratified by 63, a figure that is far from universal ratification. A victim's convention, it provides a right to truth and the right not to be subjected to enforced disappearances. The recent reports of the UN Working Group on Disappearances speak that Asia remains a continent that submitted a very high number of cases. In the drafting and negotiation process of the convention in Geneva by the then working group, intersessional working group to draft a legally binding normative instrument for the protection of all persons from enforced disappearances, getting the Asian support to this convention and to an independent monitoring body was like finding a needle in a haystack. So I will speak on our campaign strategies in some Asian countries based on my more than 2 decades of experience in AFAD as Secretary General then, and in my work in ICAED before and now. To mention a few countries in Indonesia, Nepal, Philippines, Sri Lanka, South Korea, Thailand, strategies conducted in recent years necessitated a review of the context of each country to tailor fit the campaign and advocacy according to the situation. At the national levels, efforts conducted include highlighting prominent cases such as that of lawyer Somchai Nilapayjit of Thailand, Jonas Burgos of the Philippines, Sombas Somphone of Laos, Masood of Pakistan, Wijitukul of Indonesia, Jongyung Nam of South Korea, Project Ekna Ligoda of Sri Lanka, and relating these with the equally important general phenomenon of disappearances in the region. Next is victims' empowerment in various forms, including their participation in meetings with relevant government agencies, public events like concert, government visits, media interviews, film showing, and many more. And some of these events were supported by the group of friends. University hopping to encourage academic studies on enforced disappearances and the convention. Truth-telling activities before relevant government agencies with victims' participation and representatives of government agencies, including the security sectors. Meetings with heads of states, like what we did in Indonesia and in the Philippines. Then visits to embassies, especially embassies of the group of friends of the convention, requesting Congress representatives to deliver privileged speeches during traditionally commemorated events, and the conduct of diplomatic briefings with different foreign embassies. So some of these events were also participated in by international experts. At the regional level, the same activities were conducted, but with the presence of representatives from civil society in many parts of the world. At the international levels, efforts included submission of stakeholders' report to the session of the UN Human Rights Council, participation in sessions of the Council and using it as a venue to speak to states, especially during the UPR of specific states, so that these states recommend the states under review to ratify the convention. The conduct of side events in cooperation with some members of the group of friends with participation of victims' organization and delivery of oral intervention during sessions of the Human Rights Council, holding of meetings with UN bodies to explore areas of cooperation.
Eileen, please, you have 1 minute.
writing letters to states that signed and ratified to express appreciation and encouragement, and conducting a Country of the Month campaign focusing on specific countries and requesting ICAED members to conduct various forms of actions. I'd like to mention a couple of countries here. In Sri Lanka ratified the convention in May 2015 following the visit of the working group to the country. The ratification is attributed to Sri Lanka's notorious enforced disappearances record and the national and international civil society pressures. Said ratification was followed by the establishment of the Office of Missing Persons, which provided a monthly interim allowance of 6,000 rupees, but the 5 million allowance, only 500 million allowance, 11 million was paid to only 153 families. The instrument of ratification was deposited amidst the opposition of the former parliament, which is now in power. Thus, implementation is problematic. In Thailand, by dint of international pressures pushed by the Somchai Lafayette disappearance, the May 1992 disappearances, and the cases from the South, Thailand signed the convention in 2012, which could be attributed to national and international pressures. The national organizations in Thailand, with the support of AFAD and FERIFAM, conducted lobby visits with relevant government agencies, which was followed by state recommendations during the UPR of 2011. Thailand promised to enact a domestic law against disappearances, but until now, it has been delayed. Thailand signed the convention, but it has never ratified. And another country, last, in the Republic of Korea, UPR in 2017, the NKHR, our member in Korea, sent letters to 120 states which either signed, ratified, or acceded to the convention. The letters were sent to relevant government agencies. On the third cycle of the UPR, 9 countries recommended, and in December 2017, the National Commission on Human Rights recommended ratification, but until now, the promised bill against enforced disappearances remain pending and remains a draft. So,
dear Eileen, is your time.
I would like to conclude by saying that, in a nutshell, obstacles for states to ratify the convention include, among other things, the security sector's concern on issues of heavy accountability of the state, sovereignty and independence of national courts vis-a-vis the mandate of the treaty's Committee on Disappearances, and the heavy reporting burden entailed in the monitoring compliance and prevailing impunity in many countries. Ratification of the convention in Asia is imperative, as the region is still problematic and it doesn't have efficient mechanisms dedicated to human rights. Lamentably, Asia's state of human rights remains dismal. The Victims' Convention can certainly concretize the slogan, "Never Again." Surely this convention will make a difference in the lives of victims. Thank you very much.
Thank you, Eileen, and thank you for your effort. We will now listen to Mr. Ahmed El Ghazir. Ahmed El Ghazir was born in Libya. He's a telecommunications engineer dedicated to human rights and environment issues. He co-founded Human Rights Solidarity in December 1999 in Switzerland. He is currently a senior human rights researcher and program planner at Human Rights Solidarity. Human Rights Solidarity is part of the Euro-Mediterranean Federation Against Enforced Disappearances, and Mr. Ghazir will therefore present the actions taken by the Federation to promote the ratification of the Convention for the Protection of All Persons Against Enforced Disappearances. Mr. El Ghazir, you have the floor.
Thank you very much for inviting me to this webinar. FEMED is a coalition of 27 associations against enforced disappearances. It enables the exchange of experience between associations of families of disappeared from Europe and the MENA region. FEMID's annual activities in promoting the ratification of the convention, in addition to other activities, consists of activities, the advocacy mission in Geneva and advocacy work in Paris, France. Every year, a delegation from FEMID, along with invited representatives of its member associations, travels to Geneva to carry out advocacy mission on enforced disappearance in the Euro-Mediterranean region. The delegation holds meetings with representatives of states who have not ratified the convention to raise awareness on the need to ratify the convention. In Paris, every year, FEMID observes the International Day of the Victims of Enforced Disappearances by organizing activities to raise awareness of the phenomenon and the need to ratify the convention. FEMID's members associations throughout the Mediterranean region also participate in the campaign by organizing similar activities in their respective countries. FEMID, together with Paris-based associations of families of victims of enforced disappearances from North Africa and Latin America, have created a collective of associations against enforced disappearances to combine their efforts and raise awareness on the crimes committed and combat impunity. In 2020, despite the restrictions on gatherings brought by the COVID-19 pandemic, FEMID managed to organize several events on the occasion of the 10th anniversary of the entry into force of the convention. On August 29th, FEMID organized a conference titled Justice and the Fight Against Impunity online. The panel of speakers included prominent French law professors, President of Amnesty International France, many civil society representatives from Latin America, Africa, and Mediterranean region participated with presentations about the situation of forced disappearances and activities to improve the situation in their respective countries. Initially planned as an in-person event, the conference was finally held online and was a great success. Over 5,000 people followed the event live. At the same time, an op-ed signed by more than 46 representative associations was published in the French newspaper Libération, and it underlined the importance of the convention in the fight against enforced disappearance and called on all nations to ratify the convention. The following day, a gathering was held at Paris's main square. Each year, this event aims to enlighten the public opinion by raising awareness on the state of enforced disappearance around the world. A big banner with the writing, "Ratify the Convention," was set up. The gathering also included an exhibition with portraits of numerous missing persons to drive home the reality of enforced disappearances as an ongoing violation. Lastly, advocacy meetings with embassies based in Paris. As part of its campaign to promote the ratification of the International Convention, the Paris Collective Against Enforced Disappearances contacted several embassies by mail explaining the necessity to ratify the convention. I would like to add that they initially focused on countries that from Europe that has signed the convention but yet not ratified it, to encourage them to be a role model for other countries to follow the ratification. The collective offered to meet with the diplomatic missions to explain the situation, inform them of the collective's work and activities and the necessity to ratify the convention. So far, 2 meetings are to take place with missions which express interest in the activity of the collective. 2 more conventions were held last year. One is in person in Morocco, and one was online on December the 12th, 2020, the 10th anniversary of the entry into force of the convention. FEMID, together with the collective of associations of families of the disappeared, organized an online conference.
I beg your pardon. You have 1 minute.
Okay, please. I'm finishing. The title of the conference was the International Convention for the Protection of All Persons from Enforced Disappearance. What are the results 10 years later? The aim of the conference was to review the campaigns that have been carried out in the last 10 years to promote and achieve universal ratification of the Convention and to compare successful practices. Thank you.
Thank you very much, Mr. El Ghazir. Now I leave out my summary, and it is an honor to pass the floor to my dear colleague Milica Kolakovic, university professor, high-level academic, and vice president of the Committee on Enforced Disappearances. In brief, a woman committed to these times. Dear Milica, you have the floor.
Thank you, Horacio. Good afternoon once again from my side. I would like to thank to our speakers for their brief but informative presentations. And of course, thank you, Horacio, for your efficient moderation of this part of session. Unfortunately, since we are running out of time, I have no time enough to summarize your presentations, but I would like to underline once again an importance of encouraging strategies of networks and alliances. According to agenda, we should move now to questions and answers, but I'm kindly ask you to use the chat box for that purpose in order to ensure enough time, let's say, to wrap up this discussion properly. Having this in mind, I would like to pass the floor to our distinguished colleague, Professor Gabriella Citroni from University Milano Bicocca. And of course, all of you know Gabriella, so I'm going to skip my introductory speech in order to pass the floor Gabriella immediately. Gabriella, you have the floor.
Thank you very much, Milica. Thank you very much for those who organized such an important and timely event. And I have now the very burdensome task to close such a rich event. And I think that in this richness, we have our conclusions. I have to say that I wouldn't have expected a similar event 2 years ago. Not that there hasn't been an ongoing push towards ratification of the convention, but I have to admit that at some point there seemed to be some sort of fatigue. Right now, I do not see that anymore. And this event today is a testament to the fact that there is a clear momentum for a joint effort towards campaigning for universal ratification. But I would quote something that Alice mentioned earlier. We have to dream and to aim high. We have to seek universal ratification, but together with that, we have to campaign also for implementation. It wouldn't make any case to have a universal ratification and a treaty that remains on paper. So we have to aim towards that direction. I would retain some key words that emerged today. Commitment, that was said in at least 3 different languages. And the good news is that there is a lot of that commitment across different actors, peer-to-peer states. We do have institutions that are involved and willing. We do have NGOs that are and have been there campaigning for this over the past more than 40 years. National human rights institutions, academia, and I would add to this judges, lawyers, and those who will have to use this instrument in practice. So I think that commitment is there. The second keyword is networking, and this has also been mentioned. I guess this should be done on a broad and universal level, but maybe also splitting this kind of exercise in different regions or targeting different groups where it makes, or it's easier because of whatever circumstance to reach out and network. I would say that the third keyword here is disseminate knowledge. Today, and I guess many presentations went in that direction, we unfortunately learned that there still is what I would call a toxic narrative about this convention, full of mistakes, full of stereotypes, full of myths. We have to debunk that. We have to prove that those arguments are not true. There wouldn't be any incredible financial implications or fallout. Many legal issues are actually non-issues. And I would say that even for those who would say enforced disappearance is not our problem, I beg to disagree. Enforced disappearance is a common problem. Being it a crime against humanity, against humanity, it means that it is a problem of each and every single human being. So it is a problem for each and every state. And if we do not have, and we are lucky enough not to have an enforced disappearance right now, we would like to prevent. And the convention is very strong in prevention. So all in all, I do think we have to work towards disseminating this knowledge and fighting against those false narratives. This goes hand in hand with rising awareness. I would say that there is another thing that was mentioned here and there. None of this can be done without resources. I really would love to live in a world where we do not need resources to do this, but we do. Resources in terms of human resources, resources in terms of funding. I remark what has been said at one point by Ambassador Vassou, that there might be some sort of state cooperation providing also support, technical support, financial support to push in this direction. So to wrap up, what I would say is that we listen to many different potential actions that can be undertaken. And this is also good news. This means that there is a lot to be done, and we already have ideas. But I tend to be very pragmatic. We do have to sit down, pick up those ideas and strategize and prioritize. So here I would say that we would need to, first of all, establish certain benchmarks and a timetable, if you please. That was mentioned even earlier, but otherwise it's like driving without having a clear direction. At least we do have one direction, but we do not have the map and the roadmap. We need that. We need to have priorities in that roadmap. If I want to drive to Rome, I have to need to know that I would have to cross Florence first, from where I live at least. So we need to have priorities, targets. One idea was shared by Wadi. Why don't we target some states that already signed, therefore already expressing, also from a legal perspective, a genuine wish to give a step forward? Those could be a priority. We do have 35 states that actually signed and not ratified yet. Priorities can be established on a different basis, but we do have to prioritize and choose our targets, identifying allies, identifying interlocutors, those we do want to talk to. And we do have to build strategies. How to come up with these benchmarks, priorities, and strategies and synergies? I would now steal an idea that is not mine, so I have to give the credit to Olivier de Froville. Why don't we think of organizing at one point a World Forum on Enforced Disappearance, where all the actors that are actually interested in pushing forward and in taking up this challenge for the campaign are represented and sit down and actually precisely find the targets, build the synergies, and establish priorities. I do not know, I would love it to be in person, COVID allowing, but otherwise we can still try to use technology, and the event today shows us that we could make good use of this. We could start with little, if not a World Forum, straight away with little separate events and then sum up. But I do think that we have to build on what we planted. We planted many seeds today. I would like to see those becoming realities in the near future. Thank you very much.
Thank you, Gabriela. So I believe that we somehow succeed to finish our meeting until 6 p.m. Also, I'm kindly ask colleagues if anyone wants to add something, or we are ready to go home and to spend some time with our families, but still thinking about the main messages from today's meeting. Then to go home. Thank you, everyone.
Thanks to everyone.
And have a nice evening.
Thank you very much.
Thank you.
I'm sorry
Thank
for the lack of time, and
evening.
thanks for your contribution and patience, and especially to the interpreters. Thank you very much.
Thank you. Bye-bye.
Bye-bye.
Thank you very much.